Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Let's start our week in Wexford County, Michigan. This is Judge Jason Elmore, and I believe he's about to do a sentencing.
13917 FH. Appearances, please, beginning with the Assistant AG's office.
Good morning, Your Honor. Good morning, Your Honor. Erica Tusar, on behalf of the people, P56831, assisting the Wexford County Prosecutor's Office.
Thank you.
I'm Jeff Harrison. I'm here on behalf of Mr. Hayes. He's joined me at the table.
Also joining us this morning via Zoom is Detective Sergeant Douglas Bauman. He is with the Michigan State Police and was the officer in charge of the case. Also present, though, this morning is Miss Lindsay Simmons. She is the agent from the Michigan Department of Corrections that has prepared today's pre-sentence investigation report. And again, we are here today for sentencing on 3 different charges. First, let's begin with the Assistant AG. Ms. Tusar, have you received a copy of this report? And if so, do you have any amendments or corrections or objections to the content of the report?
Yes, we received a copy. No objection to the content. I think there's one scoring that should be changed under the PRVs. And that would change the guideline range if the court accepts those changes.
All right, and what is that change?
I believe PRV 2 should be scored at 5 points because of the fleeing and eluding charge that Mr. Hayes has, which would change the PRV total to 27 points and the level to a D rather than a C.
All right, thank you. Mr. Harrison, on behalf of the defendants.
Well, this has been the subject of a great deal of discussion between myself and Ms. Simmons. And I should not speak for Ms. Simmons. I will not do that. I apologize. My take on it is that although that conviction occurred prior to this conviction, the act itself occurred subsequent to the acts that are being sentenced today. So we believe it predated, this offense predated that conviction or that offense, and it should not be counted.
Ms. Tusar, your response, ma'am.
I'll leave it to the court's discretion.
All right, thank you. One moment. All right. Well, whether or not it's scored and whether or not it's scored as a PRV2 is a different question. Is it a subsequent conviction? It occurred before this, but the events occurred after the events here, but it occurred while this case was pending. Now, another question here that I noticed is PRV7 is only scored at 10 points. I don't know why it's not scored at 20 points. Miss Simmons, do you have any response there? Because shouldn't it be 20 points for 2 or more? And he's got that felony firearm and he's got this other charge that we were just talking about.
Yeah, sure.
Yeah, so I think PRV2 should remain scored at 0, but I think PRV7 should be increased from 10 points to 20 points, which now means that the total PR, and that should be reflected on both of these SIRs, and that will increase the total PRV points from 22 to 32. And it will,
232,
I'm sorry, yep, that's all right. And let's take a look on a D grid. That is going to increase it from a C to a D PRV category. And that's going to impact the guidelines, at least thus far, by increasing it from a 29 to 38 with 29 to 57. That's on count 3 of 3, but let's go backwards. And it's, I'm going to note this, Miss Simmons. It was a little bit confusing to me as to the way you guys listed these. Like if you look at your SIRs, I have only 2 SIRs, which of course, because the first one is the 2 years. And then you listed the dead body mutilation as 3 of 3, which is consistent with CFJ 140. No, actually, it's not consistent. It's inconsistent with CFJ 145, where you listed it as number 2. So I think the SIR should say for the mutilation disinterment, that should be conviction 2 of 3.
Yes, sir.
All right, and then the next one, which is the manslaughter, should be listed 3 of 3, which is consistent with how you labeled them on CFJ 145, page 1.
Yes, sir.
Okay, all right, good. Now let's go back. We've already corrected the scoring as so, and I'm going to come back to you just a moment, Mr. So I don't think I forgot about you. So then we look at the manslaughter charge, which is a class C. That also now is going to be increased to 32 points. That's going to increase the PRV level from a C to a D, and that is going to increase the guideline range from 43 to 86 to 50 to 100.
Yep.
All right. Now, Ms.
Your Honor,
Tucci,
for clarification, you said 50?
50,
Thank you.
50 to 100.
Thank you.
All right, thank you. All right, Ms. Tussar, we were still with you. Do you have any other amendments, corrections, or objections to the content of the pre-sentence investigation report?
No, Your Honor.
Mr. Harrison, how about you, sir?
I have no proposed corrections or anything to the body of the report.
All right, I'm going to take just a quick look here to check my notes to make sure whether or not I did or did not have any. Thank you. All right, next, we know that I have a note here that there's a victim impact statement. So before I turn to the defense for allocution, I'm going to turn now to the people and the victim advocate, Ms. Sprick, who is here. Ms. Sprick is escorting a speaker to this podium. All right. Ma'am, please state for me your first and your last name.
Serena Garner,
And would you please spell them for me so make sure Nancy gets it correct?
SERINA GARNER.
Yes, ma'am. And your relationship to the victim?
I'm my dad's. That's my dad.
Your father? All right. Sorry for your loss. Thank you, ma'am. Anything you wish to say?
I have something I'd like to read.
All right. Nancy, your voice right now at the bottom is fine for me. Nancy, I know the air conditioning's on. Are you still able to pick it up?
Good.
All right, good. Thank you. Yes, ma'am. It's okay. Maybe right now we're here for you. Take your time.
My name is Serena. My dad's firstborn. He called me Bookie. He said from the first time that he held me, I was and will always be his Bookie baby. I wanted to tell you just a little bit about my dad. He was a free-spirited person who loved us girls and his grandbabies and his mom more than anything. He was so proud of us all. He had a very caring heart and he had a soft spot for helping people. mainly to help people get sober because my little sister passed away in 2020 from an accidental overdose. One of his ways of grieving and finding positive in the negative was to help people get sober, and he did help many. He loved music. He would crank up the tunes, as he would say, and sing at the top of his lungs and dance around. I remember when I was a very little, maybe 4 or 5, we cranked up his stereo and we were listening to AC/DC Dirty Deeds.
I was gonna interrupt you and ask you what was his favorite song to dance to.
He didn't have a favorite one. He liked very many songs.
All right, but you at least said AC/DC. All right, we're good.
That
Keep
was
going.
a connection with me and my dad, AC/DC. Yeah.
Thank you.
We were headbanging and dancing. The joy and connection with my daddy was one of the first of many memories I can remember. I will forever keep it in my heart. I will never forget his infectious smile and his goofy, one-of-a-kind laugh. You could be having one of the worst kind of days, and you could be so angry, and all he had to do was laugh, and your whole mood would shift to happy. My dad could always lighten the room. Also, one of the things I will miss the most. Taught me many important things in this life, like how to properly shake hands, be polite, and always help others. Always be kind, even when you're standing your ground. My dad always had good advice. I usually didn't take it, and I had to learn the hard way, but he was usually right. I remember the day that I got saved. I asked Jesus into my heart. Everyone told my 12-year-old self that I was crazy and that God wasn't real. I called my dad, and he was so excited and overwhelmed with joy for me. He taught me so many things about God and the Bible. I will forever be grateful for that too. When I was 15 or 16, my dad went to Florida to help with Hurricane Katrina rebuild and relief. Almost a year of him being down there, and I moved down with him. I was singing in my room when his friend asked me to sing in their reggae band. My dad loved my voice and wanted others to hear it too, and he always encouraged me to sing. That was some advice I'm glad I took. While down in Florida, Dad also taught me how to scuba dive. Another one of the coolest things I've done. We wouldn't have a conversation without saying, dive, dive, dive. Which is what they say when it's time to get in the water. I could go on and on about the many things that he taught me, but we would be here for many hours. I just wanted to share a few of my favorites. Last year and few months have been one of the hardest in my life. Never would have thought I would have had to hear your dad was murdered. The week before hearing those words, I had a gut feeling something was terribly wrong. Things weren't making sense. He's just going through something, or he'll call someone soon, I thought, but he never did. Instead, a sheriff knocked on my door and told me they found my dad's body on his property. His sanctuary, his happy place. I remember being numb and asking if they were sure it was my daddy. The officer replied, yes, dental records say it was him. I didn't even put together that he wasn't recognizable and he had been burned. I found that out later. From that moment forward, I struggle every day with never seeing my dad smile, hearing his voice. No more, excuse me, no more advice, No more talks, no more hugs or jam sessions. He was taken from me and his grandbabies. I've also never needed medication in my entire life. And now I take anxiety and depression medicine and sleeping medicine because when I close my eyes, all I can see is my dad burning in a shallow grave. Or him on his knees, pleading for his life or calling out to God in his last moments. Was he scared? Was he ready? I'll never know. Excuse me.
All right, ma'am. Take your time.
My oldest son asked to join counseling like I do to help with his papa being murdered and watching his mom be in so much pain and hurt and anger with all of this, and on top of being a teenage boy. My dad wasn't able to be here with me to take care of my grandma, his mom, who passed away just 2 months after my dad. I always thought I would have him and my sister to be there to help me with that, but they weren't. I also thought I would be able to be with my dad passing at home, like I was blessed to be able to take care of my grandma until she took her last breath. At home, where she loved to be, and so did he. I guess some things happen how they do for a reason. And when it's my turn to leave this earth and be with God and my loved ones, I can finally have that answer. Until then, I have to keep their memory alive and live the best I can for my babies through the hurt and find joy in things and people still here with me. Mr. Hayes, I have so many questions for you. Maybe someday will be answered, maybe not. I wanted to let you know I haven't been able to fully forgive you, and I don't know if I will. Some days I feel like I have, and others I don't. But what's more important than me forgiving you is God's forgiveness. He will without a doubt forgive you with grace and mercy. You just have to ask him and repent and mean it, because he knows your heart better than anyone. You know, my dad was battling and struggling with many things the past couple years of his life, but now he's no longer in pain. No more struggles. There's no scars or tears in heaven. Only peace, love, joy, and happiness. I believe he's watching over me and all he loved here on this earth. I can see him smiling while he's hugging my sister and my grandma, my great grandma, singing, "Every little thing gonna be all right." Your Honor, I would like to respectfully ask that you give the man who brutally took my dad's life the max amount of time in prison as possible. Thank you.
Thank you, ma'am. I just wish to confirm, Ms. Britt, were there any other victim impact statements from any, all right, thank you. All right. By the way, Mr. Gardner, the song is Three Little Birds.
Yes.
All right, just want to make sure. All right, just want to make sure you knew. Thank you. Mr. Harrison, allocution, sir.
Tough act to follow. I think it speaks well of her relationship with her father, that she was able to be so eloquent here today, and despite the excruciating, painful nature of the conversation she had, I think it expresses a great deal of a commodity that's in short supply in a lot of people's lives. That's hope. And that's something that you can't account for in a tragedy, in the situations like this, that the ripple effect, how it impacts the lives of obviously Mr. Haig, who is deceased, Mr. Hayes, who stands before you today, and their respective families, but you can see how it actually impacts other generations and people far removed from the actual location of the events in question. I'd like to be able to say that it isn't a tragedy that we're discussing here today, but even in the classical sense of the word, there's no other way to describe this. I'm also aware that we've had certain discussions about scoring and guidelines, and that kind of left two impressions with me. First of all, I guess from a practical standpoint, it's somewhat moot because if the court will recall, there is a sort of briefly stated sentence agreement pertaining to this matter that I think makes a lot of sense logically, and that it also represents the maximum of the 2/3 rule, if you will, with regard to the sentence that the court will impose here today. The other thing of it is that it often strikes me that there are things that aren't quantifiable. The guidelines deal with, for the most part, things that are quantifiable, right? The prior number of felony charges one has, the contemporaneous felonious acts, the concurrent felony charges for which one has pled guilty or been convicted. Those are all things that we can count. We come up with a number and we assign a point value for that. The non-quantifiable things are impossible to quantify, hence the name, the description thereof. And that is the emotional factor, the human element of this thing, the tragic impact that it has on the people involved. And fortunately or unfortunately, and whether it's apparent or not, that also, I would also count Mr. Hayes in that number. He's obviously had ample opportunity to reflect on the events of the day in question, the subsequent events with the involvement with the police and his incarceration in the jail for an extended period of time during the pendency of this matter. I'm encouraged by a couple of things. I'm encouraged by the fact that he is able to intelligently discuss this with me and come to an agreement so we could resolve the case in the manner that we have, so as not to, I suppose, increase the size of the ripples here by exposing this matter to a trial and all of the ugliness that is associated with that aspect of things, if you will. I couldn't think of a better word. I didn't want to say ugliness, but that's really the guttural reaction that I had to that word made it seem like it was the appropriate way to discuss that. I understand why we're here today, and I understand, I hope, what's going to happen here today. And I want everyone to know, particularly Mr. Hayes in the court, that this has been a situation that has caused me a great deal of reflection as well it should. If there's an opportunity for some growth, some good, some learning to be applied from any situation, including one with the tragic consequences of this one, I think we're wise as human beings to recognize that and endorse it accordingly. I'm not gonna belabor the point. I'm not gonna tell the court what it ought to do here. I think The answer is a parent. I think it's an appropriate recommendation because it recognizes that sentencing agreement. I think it's well thought out, it's well reasoned. And I think the course of action that we should follow here today is clearly laid out before us. We've debated this back and forth, Mr. Hayes and myself, because I do understand the court's logic, and it is logic, in these situations where we have by necessity entered a plea of no contest. You are often critical of counsel that stand before you and tell you how sorry and remorseful their client is when their client remains silent. I'm not going to do that. If Mr. Hayes wishes to express the degree of sorrow and remorse that he's expressed to me here today, I think it's appropriate that he do so. If he is unable to do so, then it is what it is, Your Honor. Thank you.
Thank you.
Your Honor,
Yes, ma'am.
sorry to interrupt, so just for clarification of the record. PRV 7, did you say that felony firearms is we're counting felony firearms and?
Well, it could either be the felony firearm, but it could also be, Matt really also scored it. The objection or argument made by Ms. Tusar was for the flee and the lewd.
Yes, I just
Wasn't
wanted
that
to
a
clarify.
felony? So it could be either one of those.
I just from reading this, as I was listening to the victim impact statement, I just wanted to make sure, because I didn't believe felony firearms could be scored under PRV 7.
Well, then I'll use the plea to lewd.
Okay, just for clarification. Thank you, Your Honor.
Thank you. All right. Before I turn to the people, Ms. Garner, did the prosecutor's office go over the pretrial agreement with you ahead of time? Okay, and I see you shaking your head, yes. All right, thank you. All right, Ms. Tusar, allocution on behalf of the people.
Yes, Your Honor. Mr. Hayes should understand that he got this deal because of the grace of the family. And I hope that he sees how much impact he made to this family in taking her father's life. But he needs to know that this came about because of the grace of the family. Thank you.
Mr. Hayes, you have the right to make a statement if you choose to do so. Is there anything you wish to say today, sir? I do respect and understand that you entered a no contest plea.
I would like to just say I'm very sorry. Everybody here in the courtroom, I know that might not help anybody, but I'm truly sorry for my actions.
All right, thank you. Well, there is one argument to say that the court need not make any statement because there was a sentencing agreement put in place as to the manslaughter charge, as well as the disinterment or mutilation charge as well. And the prosecutor's office apparently did their job. They're not required to get the agreement from a family member as to how a case should be resolved, but they do need to speak with them and take their opinions into consideration. I don't need to, nor would it be appropriate for the court to go into that communication and parse it apart. We'll take Ms. Tusar at her word. I have no reason to disagree with an officer of the court that it is the result of grace. This is or has been resolved with a no contest plea. And as Mr. Harrison is correct, I often do take issue because I have to. When the counsel say my client expresses remorse. They can't do that because the client entered a no contest plea. So Mr. Harrison's right, because this court is right in not allowing somebody to enter a no contest plea and then have counsel speak on their behalf as to their remorse. I look at this case, I've shook my head several times. Again, the pre-trial agreement ties my hands. Never a big fan of when somebody limits the court's discretion in any way, but they've tied my hands. I guess I could go below the agreement, but I'm not. So how have they tied my hands? The maximum punishment allowed under law is 2/3 of the maximum penalty. I have no choice. So I'm always cautious and concerned because often after when people leave the courtroom, whether it's on social media or whether it's in the newspapers or it's on comments or whatever, they'll like to complain about the court. I can only give one sentence today. There is no real discretion granted to this court today. It has to be the 2/3 rule. So, but I still need to be able to express, as required by appellate and Supreme Court decisions, the reasons for proportional and reasonableness of the sentence. Well, the defendant's prior criminal history is not extensive. I, of course, do not take into consideration any charges that were dismissed. I will note that one of his cases was dismissed because he got arrested on this case. And, but I will also note he had other cases that occurred while on bond, including this offense. The defendant had been convicted of a previous misdemeanor when places like Osceola County dropped their charges. He would have to serve that one and then serve this one consecutively. But he got a benefit there because he got one of those cases dismissed. When they dismissed the delivery to a minor of marijuana, an 8-year felony, when Osceola County dismissed that case, it means he got a benefit because he doesn't have to, the two sentences don't have to run consecutive to one another. And then he gets a significant benefit in this case. Oh, by the way, he had an assault with intent to commit. Hold on. So he had another felony in Berrien County, which was resolved with a 3-day jail, so that I can't run that consecutive. Let's take a look here what this case says. The court does not want anybody pointing fingers as to the sentence. The description of the offense, and I apologize to Ms. Garner, but are well described in CFJ 284A, page 4. I'm just going to read it, so I apologize to Ms. Garner. Quote, Hendricks recalled that while in the shower, she heard a loud noise like a boom and dogs barking. She hurried to get dressed, stating she was worried about the victim because the noise, quote unquote, was just not right. Hendricks recalled that when she left the bathroom, the defendant came inside and told her, quote, the victim was gone and he had to go back outside. The defendant then exited the house with Hendricks gathering her things and going outside to the defendant's truck. Once outside, Hendricks saw blood around the victim's head and the defendant pulling the victim by his feet down the hill. Hendricks stated that she knew the victim was dead. Hendricks also saw a blood trail as the defendant moved the victim's body down the hill. Hendricks saw the defendant digging a hole and the victim's body was covered with a tarp nearby where the defendant was digging. She saw the defendant put the victim's body in the hole and cover it with items that would burn. Hendricks stated that the defendant took a gas can from the victim's property and they went to a gas station to get gas so the defendant could use the gas to burn the victim's body. Once they returned home, the defendant poured gas into the hole with the victim's body inside. The defendant cut down a tree and continued to try to burn the victim's body. That case somehow has resulted in what was a potential of life as a first-degree case, and even as a second degree, it has been brought down by nearly a third of what the sentences would have been. I don't know if all that was explained to Ms. Garner. I see them shaking their heads no, which gives me concern, and that's why I asked you that question. Because the prosecutor's office needs to have gone over that with you. You don't have to get your agreement. They need to have gone over that with you. If they didn't, you can take it up with the prosecutor's office. It's not my job to do that, but now the case is mine. And Ms. Garner, I didn't read that out loud for you to hurt you. I read it out loud to put this case into context. Because lots of people watch, whether it's streaming or watch the news or listen to things on Facebook and all those other garbage media, social media sources, and they love to express opinions. I just described that so you could hear it, and then I could tell you if that, all that, and the pretrial agreement and the pleas and the sentencings and the possibilities and the evidence was not described to you, you need to take it up with somebody else. It's not that I'm saying don't bring it up to me, because I'm concerned. That's why I brought it up to you. The Victim Rights Act requires that that information or that type of information be shared with the victims before an agreement is entered. Whether or not that's done, it does not necessarily turn into a possible reason for dismissal of the case, but it's something that victims should be aware of. That's the evidence they had. They have reduced this charge. There's no way these guidelines are adequate. When I look here, I've got a 46-year-old man who has had, and I want to highlight this, got quite a little drug history here over the last few years using methamphetamine daily, which definitely, once again, I challenge anybody to ever come and argue with me as to whether or not drugs are victimless crimes. And I'll note here that when I looked at the defendant's criminal history, he was 46. I expected to see some kind of employment history. Well, I did see some kind. I saw that he worked for a year, 46 years of age. Worked for about a year and he quit that job, by the way. So now I wonder, what has this defendant been doing? What has he been contributing? I also don't have one positive statement being presented on behalf of the defendant, which is okay. Again, I'm just going in here because I'm going to cover this to make sure that it is not, at least hopefully, not appealable as to the sentence. Again, my hands are tied. The guidelines are woefully inadequate. The pretrial agreement is extremely beneficial to the defendant. The fact that other counties dismissed charges and took away the consecutive sentencing that could have been done, extremely beneficial to the defendant. A person's life was taken and the people have decided it's worth 10 years. Okay? Not the judge, although that's the sentence I'm going to give, and I'm going to find that it's reasonably proportionate. The agreement, the people have decided it's worth 10 years. I'm very sorry for that to anybody. The Court gives the following sentence. The court assesses $368 state minimum fees, one $130 crime victims' right fund fee, a $300 court cost, a $500 attorney fee. One moment. $5,663 as restitution payable to the state of Michigan. And I'm going to state this, what was the restitution for again, Miss Simmons? That's for the manslaughter charge.
Yes.
As to the count for the disinterment and mutilation, the court is going to also assess a $3,000 fine.
Apologies, Your Honor. Can you repeat the 3,000 goes to?
The disinterments and mutilation count.
Thank you.
By the way, all fines and costs are going to be made a term or condition that they must be paid before parole. The court sentences the defendant as to count one, weapons felony firearm, to the mandatory 2 years. And Miss Simmons, I think we probably need to change on the SIRs, the concurrent consecutive language we always put. It always comes out, yes, it's concurrent, when technically it's consecutive to the felony firearm.
Yes, Your Honor.
Yeah, thank you. So that is 2 years. That will run consecutive to the remaining sentences. In that case, I'm sorry, in that count, the defendant, of course, gets 399 days of credit. As to the count two for the disinterment and mutilation, one moment. This is a small point. The pretrial agreement is that the defendant's sentence would be 6, or in other words, 72 months to a maximum of 120 months. However, my calculations of the 2/3 rule would be that it would be 80 to 120 months. And technically, I'm going to violate the pretrial agreement, which is a Killebrew agreement. I'm going to make it 80 to 120 months, which would allow the defendant to withdraw his plea potentially today, but we'll see if that happens. The court awards the defendant 399 days credit. That count will run concurrent with the next count. As to the the manslaughter, the most the court can give and the most that is consistent, this is consistent with the pretrial agreement, is 120 to 180 months with 399 days of credit. Take a quick look. One moment, please. And as to manslaughter, court also adds a $2,000 fine. I find that that is reasonable. Well, hold on. Reasonable and proportionate based upon the pretrial agreement. Do I think it's reasonable proportion as to the offense and the crimes actually committed? No, it's way too low. But I make the fact that he has to make all those fines and costs and penalties paid as a term or condition of probation. Court also will obviously deny any request for boot camp, not that it'll probably come back up, but we'll make a note of that. All right, have I missed anything, Miss Simmons?
No, Your Honor.
Have I missed anything, Miss Tusar, on behalf of the AG's office?
No, Your Honor, thank you.
Thank you. Mr. Harrison is going to bring to you, Mr. Hayes, 2 copies of one document. This document tells you that you have the right to appeal the plea and the conviction and sentence. Because of the pretrial agreement, any plea must be done by filing, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for a leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the copy of that document and return to the court within 42 days. Now, again, place your initials on the first copy, neither elects nor waives any rights. It merely acknowledges receipt of the other copy of the document. All right. I will note that my sentences here exceed the guideline ranges for the count for the mutilation, which was 29 to 57. I went with 80. Based upon the factors that I read earlier, I find that the guidelines are inadequate. And also as to the manslaughter, I find that the guidelines are inadequate. I also find that my sentences are reasonably proportionate and they're based, and that's largely supported by the pretrial agreements reached in the case. All right. I know there has been some somberness today, and I know that my tone, I don't always know how to use it. In fact, I pace back and forth in my chambers. What tone am I going to use when I walk out there today? Garner, to the friends and family of your father, I'm very sorry. There's absolutely nothing the law can do to make up for that loss. Thank you for your blessings, the grace that you give, the example that you demonstrate through your faith. I myself am a person of faith, and I understand it. I often tell people, especially during the holidays, the greatest example of love, which is what Christ's life was all about, is forgiveness. That is the most difficult challenge for love. God bless His strength. Mr. Hayes, what you did here today, let's take nothing away from this. It's your fault. What you did was horrific. We are adjourned.
So, good morning once again. Welcome to the Courtroom Files Live. That was a really heavy way to start the day for sure. But you never know what you're going to get here. That's what we do. We hop around and we see what we see. But even my studio is objecting to that for whatever reason. Just as he said it's adjourned, one of my lights up there just changed its color temperature at random. No idea why. So even the studio didn't like that one. So curious if anybody out there knows, I lived a lot of my life in Michigan, but I've been gone almost 20 years now, and I left before I had any passion for court stuff. Does anybody know what the law is in Michigan regarding a judge's ability to accept or reject a plea deal? Because we see all the time where judges will say, I'm not doing this. And it seemed like he really objected to that, but yet he went through with it. So I'm curious if anybody knows how bound they are there to having to accept it. If you know, let me know. Otherwise, I'll try to do some research on it because I'm curious. But we do need to lighten things up a little bit. So why don't we go to Texas and Judge West, because it's Monday, and normally there's a parade of fashion in her court on Monday. So let's see.
Good morning. Are you Monique Wynn?
Yes, ma'am.
And Miss Wynn, this is your initial appearance in cause number 24-1298. You're charged with the state jail felony offense of theft of property from April 8th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I had a lawyer.
Right, so when you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, what I'm going to do is give you some time and ask that you try to hire your own lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the people you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she'll give you a reset notice. Jamarcus Zarate Jones. Good morning. Are you Jamarcus Zarate Jones? Did you get someone hired?
Well, I talked to 3 lawyers.
Okay.
Lori,
Keep in touch with the bonds.
Lori Parenzo,
Mm-hmm.
Corey Crenshaw, and Kate John.
Okay. And so where are you on being able to get someone hired? Pull your pants up. Just wearing a belt doesn't do it. Pull them all the way up so that I can't see your underwear sticking out the front. And nobody wants to see it sticking out the back. You understand? Okay. So where are you on being able to get someone hired?
I'm not physically couldn't,
Are you working?
no,
Why aren't you working?
because of these charges currently.
Okay. Were you working before?
Yes,
How old are you?
I'm 21.
Okay. So you're on, have you been going to probation like you're supposed to?
Yes, ma'am.
So where do you live? Who pays your bills?
Family, live with family.
Okay. Hi, good morning.
Good morning. I just wanted to make you aware, the charges haven't been filed yet. We sent over, a hearing last week to second amendment because he was arrested again here in Jefferson County. So he has 2 more charges that should be filed.
What'd you get arrested for?
Just being with the wrong crowd at the wrong time.
Sounds like you are the wrong crowd. You're not? You're on probation for theft of a firearm and you've been arrested twice now? Since this, right? Is that what you're saying?
Yes, ma'am. Well, he was arrested in March, but he was also arrested, June the 18th for possession of marijuana and unlawfully carrying a weapon.
Have a seat in the jury box. We're gonna have you tested and then I'm gonna decide what to do.
All right, we'll keep an eye on Fashion Monday. She's obviously got a little bit of a pause going. Let's go to Miami-Dade, where Judge Not Glazer is once again on the bench. This is Maria Espinoza-Dennis, who we saw last week. Let's spend a few minutes with her.
2 years.
2 years. Who lives at 712 Northern Drive in Lake Park, Florida?
That's my old address on my, license.
It never changed yours. Okay. But you've lived 2 years in Dade County?
Yes, ma'am.
Do you have a name that you can give and a telephone number for somebody that can confirm that?
I don't know their number, ma'am.
This is what I'm gonna do. I'm gonna refer you to pretrial services, but the alternate bond is going to be $1,000, okay? On count
Would you like to do $1 on count 2?
$1, yes. Okay. Okay, so it's $1,000 and $1, okay?
Yes, ma'am.
No, let's make it 500 on count one and $1 on count two, okay?
Thank you.
Alternate for Collins. We did Daniel Collins or not? No, Daniel Collins, top of page 7. Is it Mr. Collins?
Mr. Daniel Collins. How you doing?
Good afternoon. Well, actually, good morning. Sir, you're charged with having committed the offense of possession of a firearm or weapon with ammunition by a convicted felon, which is a second-degree felony. I've appointed the public defender's office to represent you, and I'm going to be taking a look at the arrest affidavit to determine your bond status. How long you been in Dade County?
Since yesterday, like a day.
And so you're from New York?
Yeah.
Okay. Standard bond, $7,500.
Judge, the state's requesting an increased bond in that the defendant has no local ties. According to the arrest affidavit, the defendant has a violent criminal past, including a felony conviction from New York City. I'm looking at his FCIC and NCICs. It looks like he was released from prison last year, and that crime also involves a firearm. State's request is $25,000.
What is his conviction in that he was just released last year for?
Grabe.
Hold on.
It says criminal possession weapon -2, loaded firearm other than a person's home or business. It was a conviction. It says term 2 years, post-release supervision 2 years. And I see a release date in 24.
Released from prison in 24, but he has probation, is what you're saying?
Right, it says
He may,
parole. He may be on parole because it says 1826. And then it says parole discharge 1825. So he may have gotten off of parole in January.
said bonded $15,000. Good luck, sir.
So, Austin, thank you for citing that part of the Michigan Code for me. I'm going to have to glance through it more probably after the stream and absorb it a little better, but my initial reading on it looks like it speaks more to the defendant's ability to withdraw or having a plea vacated than it does the judge's ability to accept or reject a plea. But again, I'll give it a closer look. But you've given me a point to start with, if nothing else, so I appreciate that. But we'll get to the bottom of it for sure. Let's go back to Judge West because it looks like the parade is back in session.
Then the coroner's, I've talked to them. I talked to the Watson firm. They don't do my cases. And Harrison Davis, they don't do they also don't do my cases. And Maddie Law,
Okay. Are you working?
yes,
Where are you working?
McDonald's.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked and contacting those lawyers. You're gonna step in front of the clerk. She's gonna give you that paperwork. Make sure you fill it out accurately and completely. You're gonna swear under oath that everything's true and correct in it, and then I'll take a look at it. Okay? Ronnie Oliphant? Good morning, sir. You're Ronnie Oliphant. And Mr. Oliphant, did you get someone hired?
No, ma'am. Almost there. I'm trying to see if I can get the next extension.
Who are you trying to hire?
It was someone down in Houston that I was referred to. They had 1,000. I almost had the next.
What's the name of that attorney?
I'm not sure. I had the paperwork.
Where?
It was in my residence. I think in my car now. I just gave him a call one time and I was just gonna hire him.
Okay, so you didn't think it, when you were here before and I said, go talk to some attorneys or get someone hired, bring me the names of the people.
Right.
So I need that name. I need to know what you're gonna do. Because if you didn't talk to 3 and you're planning on hiring this one, I wanna know who it is so that next time you come in, I know that you're doing what you're saying. So I need you to figure out who it is.
Oh, yes, ma'am.
I'm gonna hold your case for just a few minutes, figure it out. Don't leave, because I'm gonna recall you back up here.
Okay.
So go figure out who it is that you talked to and who you're gonna hire.
Okay.
Lisa Pratt. Lisa Pratt.
No response, Your Honor.
Bond will be forfeited for non-appearance and reset at 100,000. Martin Ward. Good morning. You're Martin Ward. Speak up, please.
Yes.
And are you sick, Mr. Ward?
No, but I heard that call because my sister-in-law.
I can't, so since, if you're not sick, if you'll just pull it down while you're standing up here away from everybody so I can see your face and hear
My
you.
sister-in-law and both of my sister-in-laws got COVID.
Okay.
And I've had it before, so I'm just making.
No, I appreciate that. And Mr. Ward, were you able to get someone hired?
Not as of yet. I've interviewed 5 attorneys and I've decided on narrowing down to 2.
Who's that?
And both attorneys are requiring launch payment.
Just tell me who it is.
Okay, it's Scott Linick.
Mm-hmm.
And I'm trying to think of the last attorneys that I have that between that law firm and the second law firm, I'm pretty much good.
Okay. Who's the other?
Scott Linick and Benjamin Jeffries.
Okay. So if I give you one more reset, you think you'll be able to get one of them hired?
Probably need about 60 days.
Well, I only give 30-day resets, so let's do this. I'm going to reset your case 30 more days. If you're making payments to one of them or saving up, that's fine. Make sure you give me that information when you come back. If for some reason it's not going to work with those 2, there's lots of other attorneys that have different payment plans, charge different amounts. Contact some more, bring me that information. If you do get someone hired, just bring the reset notice that you get today to them and they'll tell you what to do. Okay? All right. If you'll step in front of the clerk. Shaniqua Washington. Good morning, ma'am. You're Shaniqua Washington? And Miss Washington, did you get someone hired? I'm sorry? I need you to speak up. So you already hired him and paid him money on this case? So when you were here before, I told you you had to hire a lawyer, right? So he's not just going to be your court-appointed lawyer down on this case. All right?
But he told me so you want me to hire him? But he told me to represent him with this case too.
Well, but you have to hire him to represent you. I'm not going to appoint him if you made bond. I gave you those rules when you were here before, right? So I need you to try to hire someone. It can be him, it can be whoever.
Okay.
If you can't afford to hire someone, you don't know that if you don't talk to some lawyers. That's why I ordered you to talk to at least 3. Because they all charge different amounts, they all have different payment plans. These are the same things I said last time.
Yes, ma'am. I had talked to him, told me he was going to do it, but I don't see it.
But if you didn't hire him on this case,
I understand.
then he's probably not going to be here. And I don't know if he has something on, or does Joel have something on our docket today? But you need to talk to him about actually hiring him.
Okay.
Because I won't just appoint him because you were appointed down, because it's just different down here on this court. Okay? He's not. So he's not supposed to be on our docket anyway. So I'm going to reset your case 30 days. Talk to him about hiring him, okay? If that works out, great. If it's not going to work out hiring him, talk to some others, bring me those names, and we'll discuss your options, okay? All right, step in front of the clerk. Donnell Coleman. Good morning. Are you Donnell Coleman? Miss Coleman, were you able to get someone hired?
Not someone hired, but I did talk to 3 attorneys, and I got the shortest quote, like during the period of my case pending. I had to put one job, but the shortest quote that I got was $800 from a guy, because I spoke to Charles Ross, I spoke to Thomas Burbank, and it was a guy out of Galveston I was referred to named Harry Smotherman, and he quoted me, the cheapest one I got was $800. And so I told him that I would get back in touch with him because I wanted to start working again.
Okay.
I just got a new job.
You did? Okay.
And didn't go back on the pending case that I have now.
Okay.
And so I was moving forward with going to him since he gave me the cheapest quote.
Sure. So you think if I give you a little more time, you'll be able to maybe save up and get him hired?
Okay.
Okay, so thank you for talking to those lawyers. I'll give you another 30-day reset or so. If you get them hired, great. If for some reason that's not going to work, talk to some others. As you can tell, they all have different payment plans and charge different amounts. Bring me those names and then we'll discuss your options. If you do get them hired, just bring that reset notice that you get today to him and he'll tell you what to do, okay? All right, step in front of the clerk. Yes, ma'am. Shadamon Mitchell. Shadamon Mitchell.
Well, the fashion parade is a little bit of a disappointment this morning. Hopefully it picks up the pace slightly. But we still need something a little bit uplifting, in my opinion. So, dungeon court.
Case, got a warrant issued, and looks like you got arrested on the warrant and had to post a bond.
Yesterday, yes.
Do you admit or deny you failed to appear for your review hearing?
I did.
Do you have a good reason for not appearing?
Honestly, I thought I had paid everything off. I brought my paperwork today, thinking what I had paid off. I thought I was done with coming here. I went in front of you at the last time I was in jail, and you released me from the jail with time served. So I don't know after that.
I'm not showing you paid anything on this, and you had 5 days of community service I'm not showing you did anything on this case. What did you think you did?
I don't know what case this is, honestly.
Well, you had more than one case?
He did,
Yes.
he did community service toward another case, but it's been a long time ago.
Yeah, it's been probably 2 years now. I paid it off last year.
Well, this is a case from August of 2024.
August.
That wasn't 2 years ago. That was August
Last
of last
year,
year. Driving under suspension. So, I mean, do you admit you didn't come to court when you were supposed to, or do you want to challenge that and have a hearing about it?
I mean, I wasn't here. I did have a warrant, so I mean,
Okay, it looks like you failed to appear. You got sentenced to $250 fine and court costs, and you had 5 days community service and supposed to pay your fines and court costs. And you haven't, on this case, from what I see in the record, you didn't do anything.
I can make a payment this week for sure, and I can do community service.
Okay, are you making a payment today?
I can't. I spent everything yesterday to get myself out of jail.
Okay. So let's make sure we're clear on this. You owe now, you got a $50 warrant fee. So now it's $575 total, fines and court costs and 5 days community service. And you have a bond out. So before, you got grace from January to June 29th. That's when you got arrested. Because I'll give you folks a clue. If you don't show up for a hearing, I issued a warrant The sheriff isn't gonna go out and beat your door down and come get you on a warrant for failure to appear. But you gotta look over your shoulder all the time, because that warrant's just hanging out there waiting to drop on you at any minute. And it dropped on him, what day was that? On
Yesterday.
Sunday. And you wound up going to jail.
Yes, sir.
Then it cost you $250 to get out of jail, right?
Yep.
To get
300.
showers.
Yeah, 300.
300, okay. I didn't know what he charged. So here's the difference now. When I issue a warrant to the sheriff, now if it was a murder case, maybe he would come beat your door down. But on driving under suspension, he's not gonna come beat your door down. Gary Sowers will come and beat your door down.
Absolutely.
Because he does not want to pay the court $2,500. And he will have to pay the court $2,500 if you don't show up. He will come snatch you up. And any of you other people listening, if you got a bond up with Mr. Sowers, you got to come to court. Unless you want to get thrown in the back of a car and hauled off to the jail at some time that you don't expect. That's the way this works. So now, you're on, you got to get here.
Yeah.
No excuses,
I'll
no
be here.
forgetting,
I'll
no
be here.
grandma's dying. I don't care about excuses. Get it done. Find a way to get it done. Don't find an excuse not to do it. Okay, let's set you for a review hearing. And if you get it done before the review hearing, you don't even have to come back. These are hearings to make sure you do what you're supposed to.
Okay.
If you don't show up, well, it won't be a review, it'll be a sentencing, because you got a bond. So, if you don't show up now, all I have to do is I keep this phone right here, and I text Mr. Sowers a copy of your bond. That lets him know. Within 2 days, he's gonna snatch you. He doesn't wait around.
No, I'll be here, so I ain't got to worry about that.
Okay.
Hopefully.
Are you working?
I'm trying to. I'm trying to get back to work. I was roofing. I was working with Fairfax here in Chesapeake. I got let go from that. Trying to get back into the roofing, trying to find a company I can go to.
All right, so I'm gonna set it August, I was just wondering about your work schedule. I'll set it August the 8th, that's a Friday. It'll be a sentencing at 10 o'clock. If you get it done before then, you don't have to show up. You've got 5 days community service, you got $575 in fines and court costs. And if you want to work extra community service, you get a credit on your fines of $50 a day.
Okay.
Any questions? You know what you got to do?
Yes, sir.
Okay.
Thank you.
August the 8th, 10 o'clock is your next hearing.
State of Ohio versus Billy McKenzie, case number CRA 24-497 A and B.
Billy McKenzie.
Your Honor, we were here most recently on, I think, June 6th, and there had been a day or two before that we'd appeared that Mr. McKenzie was unavailable. He was in the Scioto County Jail in connection to a probation matter. His family kept in touch with me, and he got out and got a hold of me today and said, "Hey, I'm coming in here today. Are you here?" I said, "Yeah, I'm here, so I'll stand up here with you." This is one we've been following treatment on. He's just starting into inpatient or outpatient?
Outpatient.
Where at?
Minute Reads.
He's starting outpatient at Minute Reads.
He had been at Restoring Hope, right?
I was.
He had been in the past, yes.
Okay.
So at this point, Your Honor, I don't have my file here today. I assume Mr. Hill doesn't either. I think our best bet would be just to set this back for another hearing and get a report from Minute Reads, and then kind of at that point regroup and figure out what we're doing.
Deal.
That's fine. We'd like to come back fairly soon, though.
I'm available the 7th, 14th, and the 18th.
14th. July 14th will be the next hearing.
July 14th, 10 o'clock.
And that's a preliminary hearing.
Thank you, Your Honor.
You're welcome.
Thank you, sir.
You're welcome.
State of Ohio recalls Jeremy McNally.
Okay, it's an appropriate screen. Very good. how's he doing without me reading the report?
I think we had a rule violation this weekend where he talked to a case manager into taking him personal shopping on Blackout.
He's very persuasive. May send him to law school.
I know how that went.
Okay, you gotta follow the rules.
Yes, sir.
Jeremy. Although I did them for you, you remember that, don't you?
Yes, sir. Very much. Very, very much.
Okay, well, you've made me proud in the past, make me proud going forward.
Yes, sir.
Okay, so I want to see you on August the 8th for your next hearing.
Thank you.
Thank you, Your Honor.
State of Ohio versus Brandon G. Helton, case number CRD 2318, CRD 2135, 85, A and B, CRD 2130, 53.
All right, Mr. Helton, screen is good, appropriate. This was on, it looks like you missed a hearing some time ago,
Yes, Your Honor.
back in September of 2023. Is that right?
Yes, sir.
Did you get arrested on a warrant, or you just came in on your own, or what's?
I did. I came in on my own.
Okay. Give me your story. What's going on? What's happened between September of 2023 till now?
I moved up to Waverly, Ohio, to be closer to my kids. And then at that point, I missed the court date, and I've been living up there. I work in Columbus, but it's just been weighing on me, so I figured it's time to come down and get it took care of.
Okay. Well, I applaud that.
And I plan on being...
You've got some community service and fines and costs to pay, right?
Yeah, I plan on being here Saturday for my first day of community service. I paid some on my fines today, and I plan on paying more this Thursday.
And you're working now?
Yes, sir.
What's your work schedule?
Monday through Friday, but most time Fridays. If I do have a day off, it's going to be Friday.
Okay. Well, what I'm going to do, I'll set you on a Friday for your review, and as long as you're making efforts to get your cases completed, since you're living where now?
Waverly.
I'll let you appear. You can appear on teleconference.
Okay.
You got a smartphone or a laptop?
Yeah.
Okay. You can appear by teleconference. It's a lot easier than driving in at least an hour
Yeah, a little over an hour.
from Waverly to here. That saves you 2 hours of travel time. You can appear on the teleconference for your review hearing.
What about paying my fines? Can I do that online or over the phone?
Yes.
Okay.
We have a website. Court at Lawrence County Municipal Court. Google it. The website comes up. You can play it online. You can check the status of your case online. There's a link, I believe, on there to appear by teleconference for your hearing.
Okay, yeah, I'll look into that.
And once you finish everything, there won't be any more hearings. You don't have to come anymore. So I'll set it on August the 8th, which is a Friday, at 9 a.m.
Thank you.
You are.
So I just had a question come to mind, and it's an honest question. If you have dungeon court via Zoom, is that defendant required to have a wall of shackles and chains in their home? These are the questions. I want an answer to that. I think they should. Otherwise, is it a real dungeon court experience? I highly doubt it. Let's go back to Judge West, where things might be starting to upgrade. It appears that this guy has pre-dressed in orange, at least.
Well, I be blowing them up Texas, so I've been I kind of took a conclusion. I'm trying to do like a withdrawal with him.
Okay.
Because it's like he's coming from Houston, but it's like
He's not coming.
I know about the payment, but it's like I only got discovery. You know what I mean?
Yeah. All right.
So I was gonna talk to you about, see if I can get through there and see to.
Yep. So what I'll do is reset your case about 30 days. Make sure you start talking to other attorneys soon. Don't wait till the last minute, because if you do get someone else hired, they'll need to file the appropriate paperwork to substitute in, okay?
Correct. I had got the 3 from last time we talked, but I had hired him prior and paid him like 1,800, but it's like you run about the payment, which ain't a problem, but it's like, I don't even know what's going on.
Sure. Well, okay, just, you'll get about 30 days or so. He's still your attorney. Stay in touch with your bondsman. They'll let you know when your next court date is. Okay?
Yes,
All right, you're free to go.
The bondsman's gonna let me know.
Yes, keep in touch with your bondsman for sure each week like you're supposed to, and they'll let you know when your court date is.
Yes, ma'am.
Okay, yes, sir. So we see Mr. Burbank and Mr. Adams. Okay.
Houston?
Mr. Okay.
Judge,
Yes.
on Miss Houston's case with Mr. Johnson, so you know what we're doing. You'll know the age and offense date. It's a 5-year-old DWI.
Okay.
I'm doing a reduction to a Class A. She did 5 days in jail when she was arrested.
Okay.
She's currently enrolled in a veterans treatment program in
Okay.
Houston. So I'm trying not to interfere with that, just have her continue that, with this being 5 years old.
Yeah.
That's why it's a
And I
reduction
think-
in a light sense.
Technically, I think giving credit on that isn't what we are supposed to do, but if there's nobody that argues it.
All right, well, we still wait for a proper parade there. I was hopeful with the orange that maybe something would get started, but alas, not to be. Let's go to Florida. Wade Mercer, he is doing arraignments this morning.
We use a unique system that Judge Hatcher started 30 years ago, maybe longer. What he did is he divided the courtroom into 2 halves, and it really speeds up the process and helps us move the process along pretty effectively. We ask individuals who wish to plead not guilty and speak to an attorney to sit on this side of the courtroom. We ask individuals who want to waive their right to an attorney and resolve the case this morning by entering a plea to the judge to sit on this side of the courtroom. It is entirely the defendant's choice. If you want to talk to an attorney, you need to be over here. If you want to waive that right and just plead no contest, you need to be on this side of the courtroom. And please go ahead and get where you want to be. If anyone wants to switch sides, please do this now before we call roll. All right. Anybody else want to switch sides? Plea of guilty or no contest, waive your right to an attorney. Talk to an attorney before you enter a plea. If you want to talk to an attorney, you sit over here on this side. If you want to waive your right to an attorney and plead guilty or no contest without speaking to an attorney, you sit on this side. All right. So next thing I'm going to do is I'm going to call roll. Well, actually, let me introduce myself. I already introduced myself. I hadn't introduced the 2 attorneys involved in the first appearance process. We have our prosecutor today is Mr. Jake Mitchell. Mr. Mitchell is an assistant state attorney. That means he's a prosecutor for misdemeanor and criminal traffic cases in Jackson County. Over here at the other table is Mr. John McDaniel. Mr. McDaniel is an assistant public defender. That means he does the defense work for appointed individuals that get appointed lawyers in criminal court, in misdemeanor and criminal traffic court in Jackson County. So if you ask for an attorney and if you qualify, you'll get appointed Mr. McDaniel to represent you. Mr. Mitchell is a prosecutor on all the cases today. So I'm going to call roll. When I call roll, this always gets 1 or 2 people. I need you to do 2 things. I need you to raise your hand and answer out loud. And the reason I ask you to do both things is it helps us see you quicker and know where you're at quicker. So I know what side you're seated on. So please raise your hand and answer out loud. Taylor Barnhill, not guilty side. Tierra Brantley, no contest side. Joshua Brown, failure to appear. If you hear me say failure to appear, most of those are failure to appear. So there may be some that are in jail and some that are not on the docket for some other reason. But we'll deal with those after we take care of everybody that's in the courtroom. Derek Bryant on the no contest side. Tierra Davis, failure to appear. James Delaney. Okay, Tierra Davis is a failure to appear for right now. If that changes, we'll deal with that. Traffic. I wonder where Miss Davis is coming from. That's where your husband works, right? Ain't he in charge of all that? And he's supposed to keep that roads open on court days? Cottondale, Florida, there ain't no traffic, no construction in here in Cottondale. All the construction's out where I live. It's on 90 this way. Is there no construction on 90 that way too?
Taylor's dealt with it a couple times.
Okay, so we'll see if they show up. James Delaney is on the the not guilty side. Tyler Duncan is on the no contest side. Trey Ferguson is failure to appear. Some of these may be jail cases. Again, we'll deal with those later. Dylan Folks is on the not guilty side. Alan Funderburk. Mr. Funderburk contacted the office this morning. He's having some kind of issues. He was told to be at first appearance tomorrow morning. So we'll see Mr. Funderburk at first appearance. If he doesn't show up then, I'll issue a warrant for his arrest. Deshauna Gardner is on the not guilty side. Jennifer Hernandez is on the no contest side. Rajon Higginbottom, failure to appear. James Holden is on the not guilty side. John Howard, not guilty side. Thank you. Carl Lytle or Little, not guilty side. Margaret McLaughlin, not guilty side. Charles Neal, not guilty side. Brooke Nichols, no contest side. Jasper Odom, failure to appear. Travis Purdue is on the not guilty side. Antoine Rudolph, not guilty side. Georgette Screen, failure to appear. Cameron Sherrod, not guilty side. Tremarcus Sims, I think that case has been dismissed by the state. Christopher Smith, failure to appear. Nanetta Smith, not guilty side. Chad Stile, not guilty side. Jeffrey Tipton is on the no contest side. And Teresa Zodi. All right, ladies and gentlemen, that's all the names I have on our docket today. If you're here for somebody else's case that I haven't called, I need to know that. See if you're on the wrong day, the wrong courtroom, and see what's going on. Yes, sir. What case are you here for? What's your name? Corbin Hamilton. Mr. Hamilton, give me a second. We'll try to figure out what's going on in your case. You can come on up, Mr. Hamilton, to see what the deal is. It may have been dismissed. It may be a different court date. Let's see. Corbin with a C. I have a 25 felony case, Mr. Hamilton, open on you. Do you have a charge, Mr. Hamilton, of child abuse and battery?
Yes, sir.
Did you get a notice to be here today?
Yes, sir. I was told the child abuse was supposed to be dropped on first appearance.
Okay. The notice you signed for first appearance says 9 a.m. on the 30th for battery.
Yeah.
There's no probable cause on the child abuse. Battery was set a bond of $5,000 and you had a hold for Bay County bond of $5,000 at first appearance.
Yeah.
I wouldn't have given a notice to be in misdemeanor court just because I found no probable cause, because the state still has time to look into that. Unless, the only way I would do that is if the state said, Judge, it's not going to be a misdemeanor, it's going to be it's not going to be a felony, it's going to be a misdemeanor. All right, so Mr. Hamilton, give me just a second to go back and look at this first appearance here. Case number we on? It's case number 25-273CF. First appearance was on June 4th, it looks like. That can't be right. Maybe it's not on June 4th. June 3rd. It was docketed June 4th. It wasn't docketed until the next day for some reason.
Okay, if we're going to have slow and methodical, let's have slow and methodical with somebody that will actually get something done. Let's go to Michigan, Judge Middleton.
Good morning, sir. Are you Raul David Villa?
Yes, sir.
Mr. Villa, you're here with counsel. Why don't you go ahead and place your appearance on the record?
Good morning, Your Honor. Artem Mitchell on behalf of Mr. Raul Villa, who is present and sitting to my right.
This is how they used to do it, an old formal arraignment where you'd come in and the judge would tell you what the charge is. And that's still really what the process is. Let's take a look at yours, Mr. Villa. You got some related charges, but you got a formal complaint filed by the prosecutor alleging that in May, in White Pigeon Township, you were operating a vehicle while you were intoxicated as a second or subsequent offense. It's punishable by up to a year in jail and a fine of up to $1,000. Carries 6 points on your driving record, and it requires that your license be suspended. They also charge you with improper lane use and refusing a preliminary breath test. You've retained counsel, and that's fine with us. I'll say this, Mr. Mitchell, I think you know this. I'm the sobriety court judge, and we're always on the lookout for people that might be a fit for sobriety court. There's a couple problems here. One, he lives in Branch County. But that isn't a game stopper. We've had a number of people from Bronson, Coldwater, Quincy participate in our program. Mr. Villa, if you get convicted of this charge, your driver's license is going to be revoked, meaning you won't be able to drive a car for 5 years. Unless there was a conviction and you were placed in a sobriety court treatment program, you'd be able to get your license back after 45 days with an interlock device. I don't know anything about this other than what I just told you. So I'm going to set this for what's called an attorney pretrial. The next one is July 11th, and that's probably too soon, and it's also packed. So Mr. Mitchell, does August 1st, Friday, August 1st at 8:30?
I'm actually going to be out of the state at that point, Your Honor, on August 1st.
Well, heck. How about August 15th?
August 15th, I believe will work. If I may just double check my schedule here. I want to inadvertently say something that isn't true.
Some attorneys have trouble getting phone service in this bunker of a room we're in here, but
You know, I have in the past, but luckily it's not happening right now. And actually I am free August 15th.
all right, well, that'll shift it back to Judge Patterson's pretrial date, but I will set a attorney pretrial for August 15th.
Your Honor, if I may, since we're here and talking about the OWI court and you are the OWI court judge, you said Branch County is not necessarily a deal breaker. What is the factor that the court looks at to see if Branch County would be a deal breaker? I know my client lives approximately 30 minutes away from here. so
Well,
it's
if
not
he
too
was
far.
willing to do it. Like I said, we've had people, now, if he lived in LaGrange, we couldn't do it. If he lives in Indiana, he's not eligible. But we've had people from Calhoun, Kalamazoo, Berrien, Cass, Pawpaw. So if they're willing to do it, now, at one point, many counties didn't have a sobriety court program. I think Branch County is about the only one around that does not. So, for example, if somebody from Three Rivers got arrested in Kalamazoo, they could be transferred to the Kalamazoo treatment court. Or vice versa. If somebody from Kalamazoo got arrested down here, they could be transferred to Kalamazoo. So there's a protocol for transferring cases back and forth. But if somebody's willing to participate in our program and they live half an hour away, they're certainly welcome.
Excellent.
Now, let's talk a little bit about this. I'm going to set this for an attorney pretrial for August 15th at 8:30. And it's helpful that you were here so we can clear that date right now. July 11th is too soon. August 1st would be my date. I get the first Friday of the month. Judge Pattison gets the third Friday of the month. Your lawyer's going to get the police report. I don't know if they're laboratory reports, police reports, search warrants, photographs, whatever there is to get. He'll get the report and get the information from the prosecutor. And he'll be in a position to discuss this with the prosecutor and even discuss perhaps sobriety court. I don't have the bailiff in here yet, but I'll ask you to take the file out. You're an officer of the court. And get a notice for that April 15th pretrial.
Thank you, Your
And
Honor.
then you can get this stuff from the prosecutor's office and see where we go.
Thank you, Your Honor. Do I just take the file to
Yeah,
the
I'll
district
just
court
give you
clerk's
this.
office?
Yeah, right out to the clerk's office.
Awesome. Thank you, Your Honor.
Thank you. All right, so now I don't have the public defender yet, so.
Are we all set, Judge?
All right, yes, I'll
Thank
see
you.
you next time.
Thank you, Your Honor.
All right, for those that didn't hire a lawyer, we're always prepared to appoint an attorney to represent you. We'll discuss that as we get further into the process, but as soon as the public defender comes back in, we'll pick up where we left off. I don't have a list of names and I don't have a public defender.
Is it just me, or is there a lot of disorganization this morning? It's definitely a Monday in the courts. Let's go to Kansas. Judge Webster. Let's say hi to her.
Your Honor, I'm going to need to speak to my attorney in the breakout room today.
What is your name, please?
Liddell Washington.
Can we put his name on the screen, Mr. Washington? Who is your attorney?
Darren Patterson.
All right, folks, when I tell you to call your attorneys the day after, or the day of court when they're assigned, you need to do that. I'm not saying you didn't, Mr. Washington, but for all of you listening, if you have an attorney, don't wait till the day of court to talk to that attorney.
Okay.
Let's see, is there anyone else we need identified on here? It looks like most people are. Looks like it. Jen, I don't want to give them much time on this. They need to talk quickly, so if they don't come back soon, we're going to need to bring them back.
You just let me know when, Your Honor.
All right, I'm thinking right now.
I have called them back.
Thank you.
Thank you, Judge.
You're welcome. All right, back on the record in 23 CR 437, all parties as before. Mr. Patterson, how does your client wish to respond to the violations alleged that he has never reported?
Your Honor, to the warrant to show cause, my client would waive hearing, stipulate to the violations.
Mr. Lemoyne, is that correct? You understand you do have a right to deny that this allegation and that you can make the state present evidence, but you wish to waive that right?
Correct.
And you wish to agree that you've never reported to probation?
Yes.
All right, I find that you have violated your probation. I revoke your probation that was entered on January 27, 2025. Recommendations for disposition from the state, Mr. Regier.
Your Honor, some recent information has been brought to my attention regarding this case, which is the basis of the state's recommendations. Pursuant to plea negotiations, the state is prepared to agree to a modified sentence of time served with credit for time served. I believe Mr. Smith is in a position to speak as to the actual credit for time served, but that would be the state's recommendation.
Mr. Patterson, your recommendation?
Judge, we'd ask court to adopt those recommendations. Judge, in this case, there is a 120-day controlling sentence. He did serve part of that before being sentenced by this court, had approximately 56 days of credit at that time. After he failed to appear, he did contact.
Okay, I'm sorry, Mr. Patterson. Let me take that down. Initially, how much did he have prior to sentencing?
56 days, Your Honor.
All right.
Following the warrant being issued, Judge, he did contact his probation officer, had discussions about turning himself in, and in fact did turn himself in, knowing he was going to jail. He did go to jail. Based upon that, he got an additional 49 days credit, so that he is now at 105 days jail in this case. We are asking the court to consider modifying the sentence to 105 days and closing it at this point. Thank you.
Mr. Smith, you had something to add?
No, Your Honor, just the fact of the jail dates, the accuracy that Mr. Patterson had outlined is accurate, that he has served 105 days of a 120-day sentence.
Well, Mr. Lemoyne, I'm not very happy that you totally blew off the order for probation. What in the world did you blow that off for?
There was a domestic dispute between my dad and I.
So you and your dad got into a domestic dispute and you decided you didn't have to do what the court told you.
Correct, Your Honor.
Well, since the sentence was for 120 days, you're going to serve the 120 days. You're going into custody right now, and you will serve the balance. And that, from the court's perspective, is unfortunate that I can only give you 15 days, but that's what you're going to serve until you complete this 120 days. If there's nothing further, we'll be in recess. Officer, be sure you take him into custody to serve the balance of his sentence.
Okay.
All right. Now, we have someone at the Butler County Detention Facility, apparently.
Thank you, Your Honor. If that's my only case, if I may be excused.
You are excused. Thank you, Mr. Smith.
Thank you.
Yes, Your Honor.
Who would you like to bring up for us?
Yes, Your Honor.
Who do you have there at the detention facility?
Mr. Breed and Mr. Dykes.
Which one do you have closest to you there?
Mr. Breed.
Let's bring in Mr. Breed. Mr. Patterson, have you spoken to him?
I have spoken to him, and I am just now emailing Mr. Regier what my requests are, but it might be quicker to do it in a breakout room if the court would allow.
Yeah, make it brief, though.
Yes,
Thank
Judge.
you. Mr. Regier. Jen, would you put Mr. Regier and Mr. Patterson in the breakout room? And you are Joshua Casey Breed, is that right?
Yes, ma'am.
Okay. Mr. Smith, are you just staying because you want to? You said you don't have any other hearings.
Yes, Your Honor.
All right, well, you're welcome. I know you
Thank-
like to sometimes take notes, so thank you. I just wanted to make sure I understood correctly.
Yes, Your Honor. I can't guarantee that I'll be available the whole time, but I'm going to try to keep it open just in case.
All right, well, I appreciate that. Thank you.
Yes, thank you, Judge.
You're welcome. And Mr. Washington, I'm going to need to have you find a quiet place to sit and wait and not be walking around.
Okay, that's what I'm trying to do.
All right, thank you.
I just woke up.
All right, well, the rest of you need to make sure you all have pens and paper ready because you'll have something to write down. And I can't afford to wait for everybody to stop and go search for a pen or paper. Always bring one to court with you. All right, Jen, you want to bring them back?
Yes, Your Honor.
Thank you. We are on the record in 2024 TR 218, State of Kansas versus Joshua Casey Breed, Jared Regier for the state, Darren Patterson for the defendant, Joshua Breed, who appears in person in custody, and on one count of driving while suspended dating back to November 28, 23. Mr. Patterson, how does your client wish to proceed?
Judge, pursuant to plea negotiations to the one count driving while suspended, Class B non-person misdemeanor, my client would enter plea of guilty.
Mr. Breed, is that right? You wish to plead guilty or admit that you drove while your license was suspended in Butler County, Kansas on October 28th of 2023?
Yes, Your Honor.
Is anyone making you enter this plea today by threats or promises?
No, ma'am.
You understand you're giving up your right to a trial with this plea? You'll be found guilty and unable to appeal that conviction.
Yes, Your Honor.
And your license was suspended at the time, you said.
Yes, ma'am.
And you were driving where in Butler County, if you recall, from 2 years ago?
I'm pretty sure it was on the way. I just bought a truck and I was on my way home from taking it to a mechanic. And I was, I think off of 47th and Metal Arc, I believe.
Okay. That sound right, Mr. Regier?
Your Honor, the ticket in this case does appear to refer to an intersection on North Rose Hill Road and East Rosewood Street.
Okay, that sounds all right.
All right, you don't challenge that. I accept your plea and find you guilty of driving while suspended. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending the statutory minimum fine of $100, that the court impose court costs and make an appropriate determination on the issue of attorney's fees. State would be further recommending a suspended jail sentence of 120 days, subject to 6 months non-reporting probation.
Anything further, Mr. Patterson?
Nothing further, Judge.
All right, Mr. Breed, are you in custody strictly on this case right now?
No, ma'am.
And note you did have 2 failures to appear back to back in here. Are you employed?
Currently at the moment, it's in debate, but yes, I mean, I've got funds, so.
All right. At this time, your fine is $100. Court costs $108, attorney fees $250, for a total due of $458. Your jail sentence is 120 days. You'll get credit against that 120 days for time you've served on this case. And the state will need to put that in the journal entry, the number of days. Are you able to be released for probation at this time?
Possibly this afternoon, yes, maybe, I'm not sure. I'm supposed to be, so.
Okay, so are you facing a felony case this afternoon
Yes, ma'am.
with Mr. Watts as your counsel?
Yes, ma'am. Oh, yes. Yes, sorry.
Mr. Patterson, do you know anything about that matter, whether he'll be potentially released or will be released?
Judge, I believe it's on the preliminary hearing control docket, so may or may not.
And Your Honor,
Okay.
that
Yes.
is the state's understanding as well. I am showing another Butler County case that appears to be scheduled for hearing this afternoon, 25 CR 187.
Judge, I did talk to my client. If the court would adopt these recommendations, I think he can get it paid off within the time the court would normally allow of 90 to 120 days.
I'll give you 90 days to pay from today. My question though is, I don't like to give probation to people that can't report.
Judge,
And
it's requested a non-reporting probation.
I understand. That's a good point. All right, I am going to give you a 6-month non-reporting probation. That probation has 2 conditions: pay within 90 days and do not violate any more laws from today. Going forward for 6 months, do not violate any more laws. Get this paid in 90 days, and you won't have to serve your 120 days. But if you violate your probation, it can be revoked and you can serve the balance of your 120 days.
Okay.
All right, if there's nothing further, we'll be in recess on this matter.
Judge, one more in custody, Isaiah Dicus Sutzman.
All right, he has 3 cases, it looks like, and you're appointed on all of them, Mr. Patterson, as you know.
Yes, Your Honor.
Have you talked to your client on these matters? Have you talked to Mr. Regier? Are we going to need some time on these?
Yeah.
All right, we are on the record in 2023 TR 3035, 2025 CR 184, 2025 CR 186, each case captioned State of Kansas versus Isaiah David Dicus Saltzman, County Attorney Jared Regier for the state, Darren Patterson for the defendant, who also appears personally in custody from the Butler County Jail. Mr. Patterson, how does your client wish to proceed on these matters today?
Judge, on the 2 most recent cases, I do not have discovery at this point. Would need to request additional time to get discovery. Given the nature of the charges, I just can't move forward without having the videos and reports. So would be asking for continuance. Would also inquire of the bond amounts on each of those cases.
Well, starting with 23, a driving while suspended charge dating back to July 23rd, 23, for which the defendant has had one bench warrant. Let's see. 2 bench warrants. 3 bench warrants. Well, I hope that bond's a little higher than what I'm seeing there, but it may not be. We started out with 1,000, 2,000. Mr. Regier, I'm not showing anything above 2,000 on that, are you?
Your Honor, may I have 30 seconds to review these matters?
Please do. Make sure I'm not missing something here.
Your Honor, it would appear that in these 3 cases actually before the court today, bonds have been executed. In 25 CR 184, I am showing a $2,500 professional surety bond. In the 2023 TR 3035 case, I am showing a 2,000 professional surety bond. In 25 CR 186, I am showing a $5,000 professional surety bond. However, it is the state's understanding that there's a 4th case that was most recently heard before Judge Crum earlier this month, 25 CR 190. It would appear that a request for bond modification in that case was made at that setting. I was not present, although my colleague Ms. Pierce was, and it would appear that such a request for modification was denied by the court.
Is that a felony or a misdemeanor?
Your Honor, the state's information is that is a felony case.
And you think that's the one he's being detained on, not the 3 misdemeanors that he's already posted?
Your Honor, I am showing appearance bonds in the 3 misdemeanor cases. I am not showing appearance bond in my file with respect to the felony case.
Mr. Patterson, I'm not totally confirming that at this point, but does that help with your issue on bond?
It answers my question, Judge. I just didn't know. So at this point, we just ask the court to continue it to whatever date is available so that I can get all the reports and then meet with my client and talk about those.
Very well. Let's see. Jen, is there any way you can give me a date anywhere in the reasonable future, but without having to go into September and October?
One moment, Your Honor, I will look.
Thank you.
Would this be for all 3 cases?
It would be. And maybe we could get Judge Crum to take all 4 of them. Who knows? I don't know if his calendar is quite as packed as mine. It might be.
I wouldn't have any objections if Judge Crum would. We can check with him, Judge.
All right. Well, let's get a date tentatively. Let's from Jen for all 3, and then we'll see if Judge Crum has time and desire to take all 4.
We could squeeze him in on June 21st.
Okay.
July 20.
It must mean July 21st.
No.
I heard June, but we're on June 30th, so maybe that's why that day looks so good.
You are right. It was July 21st. I apologize.
No reason to apologize. July 21st. Do you want to do that, Mr. Patterson?
Thank you. That'd be great, Judge. Thank you.
Okay, July 21st, 9 a.m. We'll take these back up. But counsel, I still would not discourage you from checking with Judge Crum and see if he wants all of them.
Judge, I will do that.
If he'd be willing to take them.
Yes, I will ask him if he would be willing to, Judge.
I would appreciate that greatly. Anything else, counsel?
No, Your Honor.
It's the court continuing the bonds in all three of these cases, and the
Yes,
state would
right.
also request a formal ruling, given the interwoven nature of these cases, as to whether or not this is being continued at the defense request for speedy trial purposes.
I am ruling that these are all being continued at the defendant's request for speedy trial purposes. The bonds are all being continued with the added condition that Mr. Dykus Saltzman stay available and in touch with his attorney, Mr. Patterson, as well as his attorney on the felony case. And that you appear here July 21st at 9 a.m. on these three cases, unless Mr. Patterson arranges something else and lets you know. So that being said, we'll be in recess. Mr. Dykus Saltzman is excused. Did you want him to stay on and talk to you, Mr. Patterson, now, or we can contact him later?
I will contact him later, Judge.
All right, thank you. Then Mr. Dykus Saltzman is excused, and I think that's your last one at the jail, you said, Deputy?
Yes, Your Honor.
Thank you. Then you're all excused too.
Let's change it up. Let's go a little further west, Adams County, Colorado, where there is a zebra parade for bond hearings going on.
Let's talk to Gerardo Perez Morales.
Thank you. Mr. Perez Morales. Gerardo Pérez Morales, por favor, pase.
All right, good morning, sir. This is 25 CR 1833. Can I have appearances?
Muy bien, buenos días, señor. Estamos en la en la causa 25 CR 1833. Entren sus comparecencias, por favor.
Ebenezer PG for the people.
Ebenezer PG para la fiscalía.
Montana Fay on his behalf, Judge. He appears in custody with the assistance of a Spanish interpreter.
Montana Fay, su señoría, representando al acusado que está aquí en persona por medio de un intérprete en español.
I will begin by issuing a protection order in your matter, sir.
Señor, voy a empezar entonces emitiendo una orden de alejamiento.
Due to the domestic violence allegations, I find it is governed by Brady.
Dado a las acusaciones, están gobernadas por Brady.
Alleged victim is Elizabeth Escarcega.
La supuesta víctima es Elizabeth Escarcega.
Date of birth is 1/24/81.
Fecha de nacimiento 1/24 del 81.
And I'll activate provisions 1 through 8B.
Voy a activar las provisiones 1 al 8B.
This means that you shall not harass or intimidate her.
Esto quiere decir, señor, que usted no podrá acosar o intimidarla.
You shall stay away from her home and any location where she may be found.
Usted tiene que estar de retirado de la casa de ella o cualquier sitio donde ella se encuentre.
You may not contact her directly or indirectly.
No la podrá contactar directamente o indirectamente.
You may not purchase, possess, or control firearms, other weapons, or ammunition.
Usted no podrá comprar, estar en posesión o controlar alguna arma de fuego o alguna arma o amunición.
And you shall relinquish any such objects within 24 hours of your release.
Y usted tendrá que entregar como tendrá que decomisar entonces cualquier objetos de esa índole dentro de 24 horas en cuanto usted salga.
You shall complete an affidavit and file it with proof of relinquishment within 7 business days.
Usted tendrá 7 días para entregar una declaración juramentada por escrito sobre el hecho de que ha decomisado entonces esos artículos. Como digo, son 7 días.
You may not possess or consume alcohol or controlled substances.
Usted no podrá estar en posesión o ingerir alcohol o sustancias reguladas.
Conditions of this protection order will also be conditions of your bond.
Condiciones de esta orden de alejamiento serán condiciones de la fianza.
So if you violate any of these conditions, you could be subject to additional criminal or contempt sanctions.
Si usted entonces quebranta alguna de estas condiciones, usted será sujeto y adicionalmente estar en sanciones penales y I'm sorry, Your Honor.
No worries.
y estaría usted en rebeldía.
And you'll need to sign a copy of this as soon as we're finished speaking.
Y señor, en cuanto terminemos de hablar, usted va a tener que firmar una copia.
The district attorney has no objection to a personal recognizance bond in your case.
Fiscalía no tiene objeción a que usted pueda salir bajo palabra en esta causa.
And I agree that's appropriate, so I will give you a PR bond in the amount of $2,500.
Yo estoy de acuerdo que pueda salir bajo palabra en la cantidad de $2,500.
So that means you don't have to post any money to get out of jail. So as long as you show up for your next court dates, you're going to be okay.
Lo cual quiere decir, señor, que usted no tendrá que pagar nada. Yo creo que esto es apropiado, pero si usted no se comparece a la próxima audiencia, lo tendrá que pagar, pero tiene que comparecerse a su próxima audiencia.
Your next court date will be July 2nd at 1:30 p.m. Division R2 for return filing of charges.
Entonces, señor, la próxima audiencia se va a llevar a cabo el 2 de julio a la 1:30 de la tarde en la división R2 para la presentación de cargos.
All right, good luck, sir.
Suerte, señor.
Thank you.
And Your Honor, could I borrow the interpreter for a moment for paperwork?
Absolutely.
Sir, do you possess a firearm?
Señor, ¿usted está en posesión de un arma de fuego?
No. Mark box 1 for no.
Marque la casilla 1 para no, por favor.
And if you could print your first and last name on the top line and then below signature.
Si puede escribir su nombre completo en el renglón de arriba y su firma en el renglón de abajo.
And again, if you can print your first and last name on the top of the line and below your signature.
Y de nuevo, si puede poner su nombre completo, su primer nombre y apellido, y luego su firma.
Here. Uno, dos. Here. Perfect. And here's a copy for your record, sir.
Aquí está una copia, señor, para sus récords.
Okay. Puerta. Gracias.
All right, let's talk to Rufino Zuniga Martinez.
Thank you.
Entonces, el señor Rufino Zúñiga Martínez.
Good morning, sir. This is 25T7630.
Buenos días, señor. Estamos en la causa. I'm sorry, Your Honor, 24 or 25?
25T7630.
25T787630.
Can I have appearances?
Las comparecencias.
Montana Fay on his behalf.
Montana Fay a favor del compareciente.
All right, sir, I will let you know that the district attorney has no objection to a personal recognizance bond in your case.
Muy bien, señor. Entonces le voy a dar a saber que la fiscalía está de acuerdo a que usted pueda salir bajo palabra.
And I'm going to grant you one today in the amount of $10,000.
Y le voy a otorgar uno en la cantidad de $10,000.
That means you don't have to post any money to get out of jail. So as long as you show up for your next court dates, you're going to be okay.
Eso quiere decir que usted no tendrá que pagar nada para salir de la cárcel mientras usted se comparezca a su próxima audiencia. A sus audiencias estará bien.
And that will be with the conditions of the supervised release program and monitored sobriety.
Y eso va a ser en conjunto al programa de supervisión y monitoreo de sobriedad.
All right, your next court date will be July 7th at 1:30 p.m. Division FAC for an arraignment.
Y la próxima audiencia se llevará a cabo el 7 de julio a la 1:30 de la tarde en el Departamento de Primera Instancia para una acusación formal.
Okay. Good luck, sir.
Buena suerte, señor.
Okay, be out today. Good luck.
All right, let's next talk to Edgar Medina.
Oh, he doesn't.
Edgar Medina.
All right, good morning, sir. This is 25 CR 1839.
Buenos días, señor. Este es el caso 25 CR 1839.
I have appearances.
Las comparecencias.
Montana Fe on his behalf. He appears with the assistance of a Spanish interpreter.
Montana Fe a favor del acusado con la ayuda de un intérprete en español.
And on behalf of the people?
A favor de la fiscalía.
For the people.
Ebenezer Apagi para la fiscalía.
All right, so I'm going to begin by issuing a protection order in your case.
Señor, voy a empezar entonces emitiendo una orden de alejamiento en su causa.
Due to the domestic violence allegations, this is governed by Brady.
Dado las acusaciones de violencia doméstica, esto está gobernado por Brady.
I will activate provisions 1 through 8B.
Y voy a añadir o activar las provisiones 1 al 8B.
Alleged victim is Manicela Bravo Chavera.
La supuesta víctima es Marisela Bravo Chaverra.
Date of birth 7/3/05.
Fecha de nacimiento 7/3 del 05.
Ms. Fay, will he need a civil assist?
Yes, please.
Señorita Fay, ¿necesita ayuda civil? Sí, su señoría.
All right, then I will authorize one.
Autorizaré una.
All right, so this means that you shall not harass, molest, or intimidate her.
Señor, esto quiere decir que usted no podrá acosar, molestar, intimidarla.
You shall stay away from her home and any location where she may be found.
Usted tendrá que estar retirado del lugar de la vivienda de ella o cualquier otro sitio donde ella sea encontrada.
You may not contact her directly or indirectly.
Usted no la podrá contactar a ella directamente o indirectamente.
You may not possess, purchase, or control firearms, other weapons, or ammunition.
Usted no podrá estar en posesión, comprar o controlar armas de fuego, armas o munición.
You shall relinquish any such objects within 24 hours of your release.
Y usted tendrá que renunciar el hecho de tenerlas tendrá que entregarlas si es que usted las tiene dentro de 24 horas después de que salga.
You shall complete an affidavit and file it with proof of relinquishment within 7 business days.
Usted tendrá que llenar una declaración juramentada y emitirla como comprobante de que usted ha entregado esas armas y munición dentro de 7 días de haber salido.
You may not possess or consume alcoholic beverages or controlled substances.
No podrá estar en posesión o ingerir bebidas alcohólicas o sustancias reguladas.
I'm allowing you one civil assist so that you can go back to the shared residence and retrieve your personal belongings.
Le voy a permitir una ayuda civil donde usted sería escoltado por el departamento de sheriff para que usted vaya a recoger sus cosas.
That will be with the accompaniment of a sheriff's deputy, and you will have to set that up.
Y eso será acompañado de nuevo por medio de con un sheriff y usted tiene que hacer esos trámites.
Conditions of this protection order will also be conditions of your bond.
Las condiciones de esta orden de alejamiento también serán condiciones de su fianza.
And if you violate any of the conditions, you could be subject to additional criminal or contempt sanctions.
Y si usted quebranta alguna de estas condiciones, entonces usted será sujeto a cargos adicionales o sanciones por desacato.
And you'll need to sign a copy as soon as we're finished speaking.
Y usted tendrá que firmar una copia en cuanto terminemos de hablar.
All right, Ms. Fay, regarding bond.
Señorita Fe, referente a la fianza.
Judge, we recognize that the allegations are serious, but Mr. Medina has never had any contacts with the criminal justice system.
Su señoría, nosotros reconocemos de las acusaciones son muy graves, pero el señor Medina no ha tenido ningún contacto con el sistema judicial penal.
He has many ties to the community, including a young daughter who he supports and a job that he's had for the past year as a barber.
Entonces, él tiene vínculos a la comunidad, tiene una hija pequeña, la cual él mantiene, y también tiene un trabajo donde ha trabajado como barbero el último año.
He does not share any children with the named victim, and there will not be any issues complying with the protection order.
No, él no tiene ningún hijo o hija con la supuesta víctima y él va a seguir todos los requisitos necesarios de esta orden de alejamiento.
So I am asking the court to consider non-monetary conditions such as the protection order as conditions of his bond.
Pidiendo su señoría de que usted no ponga condiciones monetarias como protección de la orden de alejamiento como condición de la fianza.
He's never failed to appear. He's never violated a protection order. There's no history of any alcohol, violence, anything that should concern the court.
Entonces, él se ha presentado, bueno, no tiene ningún cargo de que no se haya comparecido, nunca ha quebrantado una orden de alejamiento, no tiene antecedentes penales o de violencia de alcohol y por eso, su señoría, usted no debería de estar preocupado referente a ello.
So I am asking the court to authorize a personal recognizance bond and allow him to fight this case out of custody.
Y por eso, su señoría, le estoy pidiendo de que usted autorice que él pueda salir bajo palabra y él pueda pelear su caso fuera de custodia.
Thank you, Mr. Epieghi.
Señor fiscal.
Your Honor, this time people will object to personal recognition bond. I do understand about the CPAT risk category, but the facts of this case is very aggravated. It's a second-degree assault strangulation. This individual is alleged to have held the victim by the neck and lift her up. People are very concerned about the safety of the victim at this time. And so at this time, people will be asking that the court deny personal recognition bond and issue a cash surety as scheduled.
Entonces, su señoría, nosotros a la fiscalía está muy preocupado, su señoría, de estas acusaciones que vendría siendo del segundo grado con agravantes. Y su señoría, esto es el segundo grado de estrangulación, donde hay testigos, su señoría, de que él la agarró por el cuello y la levantó del piso. Entonces, la fiscalía está muy preocupado por la seguridad de la víctima y por eso es que en estos momentos nosotros negamos de que él pueda salir bajo palabra y pedimos de que usted siga los requisitos y según las pautas, dinero en efectivo y fianza.
Thank you. Sir, I'm going to issue a bond alternative.
Señor, voy a emitir una alternativa a fianza.
It's either going to be 5,000 cash surety or a $500 cash only option.
Sus opciones van a ser entonces $5,000 dinero en efectivo o 500 por medio de casa de fianza o $500 en efectivo.
And while I recognize your absence of criminal history, I am very concerned about the allegations in this current case.
Que yo reconozco la ausencia de antecedentes penales, estoy muy preocupado por estas acusaciones.
Next court date will be July 2nd at 1:30 p.m. Division R2 for return filing of charges.
La próxima audiencia se llevará a cabo el 2 de julio a la 1:30 de la tarde en la división R2 para la presentación de cargos.
All right, good luck, sir.
Buena suerte, señor.
All right, let's speed things up a little bit. We're going to go back to Florida and Wade Mercer, but he's not doing arraignments now. We're over to first appearances.
Mr. Leonard, I've read the complaint. There is probable cause for that charge. Your mother's in the courtroom. I do see at least one prior battery charge on your history within the last couple of years in Marion County in 22.
That was in a juvenile program.
There's a battery on the person in a detention facility. That may be the same charge. It may not be. And I think that may be about, well, let's see, that maybe 2 batteries. Yeah,
Those are like
2 different
two-
ones. One in February and then another one in April of 22. That's what the rap sheet shows. Mr. Leonard, the information I've got shows that you are 19 years of age and you're unemployed. Are you a student, sir?
No, sir. I am employed. I have a job at Winn-Dixie. I start tomorrow.
Okay. Let me see if the attorneys have any additional information before I address your bond status. Mr. Mitchell, anything?
No, Your Honor. Did
Mr.
you also want to address who he has here?
I told him
Oh,
some
okay.
others here.
All right.
Yeah.
I didn't know. Sorry.
Mr. McDaniel, anything? No, Your Honor. Mr. Leonard, I'm going to set you the standard bond. I've only set for third-degree felony. I'm not going to give you a conditional release because of you've got a history of at least 2 battery charges, it appears, as well as you're currently unemployed. I know that you're supposed to start a job, but that's not the same as having a job that you've already started. But I'm going to set you the standard bond I normally would set for this charge, which is $5,000 cash or surety. Cash or surety, Mr. Leonard, means you don't have to come up with all $5,000. You can go through a bondsman. That's what a surety bond is. So, ma'am, a surety bond for $5,000, normally that's going to be around $500, but that's negotiable with the bondsman. Some bondsmen may take a little less than that and then work out some kind of payment plan. But as soon as he posts bond, or if you post bond, he'll be released. Mr. Leonard, do you have a condition of absolutely no contact with the alleged victim in any form? That means telephonic, electronic, texting, no contact at all. If she wants contact and if you want contact, I'll consider that at a later date and time. But right now, no contact, and you'll get to use the phone shortly. Let me see if your mother has any questions first. Ma'am, do you have any questions? Mr. Leonard, do you have any questions?
No, sir. I stay by myself, so I can't I can't stand here very long because I stay by myself. And I don't know if I don't really have the money right now to pay the bond. That's why
If this was your first arrest, you might be a conditional release officer, but an officer conditional release may be a possibility. It's not your first charge, and it's to go to a juvenile facility means that you've got prior juvenile history. I don't have, most likely. So, Mr. Leonard, that's the bond I'm setting you. Any questions?
No, sir.
Have a good day, sir. Ladies and gentlemen, I know we've had several people come in the courtroom. Is there anybody else that's came in on the first appearance case? Somebody at jail this morning? Okay. I think that may be it for family and friends, Corporal. So let's go back to the top of the list, which is Hannah Eastwood. Miss Eastwood, good morning. Miss Eastwood, you're here because you've been accused of 1 count of battery. Miss Eastwood, I've read the complaint, I think 3 times, trying to determine if there's probable cause or not. And I want to see if the attorneys have an additional input on that issue. Mr. Mitchell, anything on probable cause from the state?
Your Honor, we've looked over the complaint. Oh, sorry. We've looked over the complaint, and yes, we're in agreement that marks on the face and them denying physical contact with each other doesn't exactly equal a battery. And plus also the complaint says that a primary aggressor was unable to be determined. So we're in agreement on that part.
Thank you. Mr. McDaniel, anything?
Nothing else.
Miss Eastwood, I want to find no probable cause. Battery is the unwanted touching or striking of another person against their will. There is 0 evidence of that, with the exception being this. This is the evidence in the complaint. Contact was made with Hannah Eastwood and her boyfriend, Logan Brewer. I noticed several scars and wounds to Eastwood's wrist and forearm, some old and others fairly recent. Brewer was observed with a red mark on his upper forehead. Both denied any physical contact. So having a red mark on your upper forehead can happen a million ways other than battery. And there's no evidence to lead a reasonable person to believe that this was a result of a battery, that you intentionally touched or struck him. And the same is true for his case, which we're going to get to in just a minute. So I'm going to find no probable cause. Do you want to have contact with him, Miss Eastwood?
Yes, there's
Miss
the
Eastwood?
cuts. Yes, the cuts that were on my arm. I will admit I used to self-harm. Huh?
John.
Yeah.
Yes.
You don't need to, if you understand everything, just say yes. Okay. Do you have any questions, ma'am?
No.
All right. So what's going to happen is you're going to get out of jail this morning. I need to make sure that you keep the clerk's office with a get address. The address they have is a Carter's Mill Road apartment address. If that changes, it's your responsibility to notify the clerk of court. And here's why. If the state attorney's office is able to communicate with the law enforcement officer and he can add additional facts, they could still charge you with this crime. Because I've just found no probable cause. It's not being dismissed. The state has the opportunity to try to fix this if they can. I have no idea if they can or not, but what's there now is not enough for me to justify holding you or putting any kind of restrictions on your freedom. So you're going to be released this morning. Make sure the clerk of court has a good address for you in case they do fix the errors and try to go forward with a charge. Do you have any questions?
No,
Have a good day.
you too.
Logan Brewer.
You heard, did we address contact?
I can't put no contact if there's no probable cause.
Okay, yeah.
I can't do any restrictions to their freedom. So
That's what I was
I did ask about that. So Mr. Brewer, good morning. Mr. Brewer, your
Good morning.
situation is the same as Miss Eastwood's. There's just insufficient evidence to justify holding you for the crime of battery for the reasons I've already put on the record with her. Could you hear everything I told her, sir?
Yes, sir.
Okay, so what that means is you're going to be released also. I would tell you the same thing about making sure the clerk of court has a good address for you for the same reasons in case the state attorney's office can get law enforcement to correct the complaint. But what's there, having marks on you and someone saying you had a verbal argument is not enough for battery. I can't tell you the number of times I've come home from being out in the woods and had a scratch or cut on me and had some, there's possibly been an argument. My wife likes to do that from time to time. And that doesn't mean that there was a battery. It doesn't. So
on the record, Judge.
usually it's my fault, I'm sure. So anyway, you're going to be released, Mr. Brewer, and you will, and I'm encouraging you to be aware that you have a charge that's no probable cause at this point that may or may not be corrected, but you and she need to use a little common sense and try to find a better way to solve arguments other than yelling and fussing and fighting, arguing, whatever y'all were doing. Any questions?
No, sir.
Have a good day, sir.
You too.
The next case we have a couple of VOPs. Actually, we have 3 or 4 of them. So let me see. Angela Daniel, Jonathan Leith, Michael Hodges, and Michael Herbert.
Well, it's all at the same time?
Yeah. Yes. Angela Daniel, ma'am, you're Miss Daniel?
Yes.
Sir, you're Jonathan Leith, is that right? All right,
Yes, sir.
and then Michael Hodges.
Mitchell Hodges.
I'm sorry.
You're fine, sir.
Mr. Hodges, how do you spell your first name?
Mitchell.
Okay. And Michael Herbert on the end there. So I'm seeing you all of you at the same time because your cases are identical for first appearance purposes. Each of you have been accused of 1 count of violation of your state probation or probation or community control. And it looks like you've already been first appeared. But what we do in Jackson County is we go ahead and arraign you. If there's been an affidavit filed, I arraign you at first appearance. And the reason I do that is I can get you a lawyer appointed quicker by doing it that way. So if you want an attorney appointed to represent you, that's what we're going to do this morning. And then we'll see if you have any questions in just a moment. Miss Daniel, do you want an attorney appointed to represent you, ma'am?
Yes, sir.
Mr. Leith, same question.
Yes, sir.
Great. Mr. Hodges, same question.
Yes, sir.
Mr. Herbert, same question.
Yes, sir.
I'm going to appoint the public defender's office for the 14th Circuit to represent each of you. Now listen to Mr. McDaniel. He's going to tell you when your court date is going to be, and then I'll see if any of you have any questions. Mr. McDaniel.
Your Honor, we're going to enter a plea of not guilty as to set this on July 10th, the pretrial docket, and I've already advised them, Mr. Guy Green, to come by and speak to them prior to that hearing.
Well, the good news is that had you been first appeared tomorrow, you wouldn't have court until August. Today is the cutoff for the July 10th date. So that's another reason we're trying to keep these cases moving. So as Mr. McDaniel just said, he's going to go ahead and get you on the July 10th docket. So all of you will be in court July 10th, which is actually next week. You'll be in court next week for your VOP date, and your attorney, Mr. Green, will see you before your court date. He makes a jail visit usually the week before court. He'll talk to you about your case, the allegations against you, and any offers he may have to resolve it. Let me see if anybody has any questions. Let me first see if the state has anything. Mr. Mitchell, anything?
No, Your Honor.
Ms. Daniel, do you have any questions, ma'am?
No, sir.
Wish you the best. Mr. Leith, any questions?
No, sir.
All right, sir. Wish you the best. Mr. Hodges, any questions?
No, sir.
All right, sir. Wish you the best. And Mr. Herbert, any questions?
There ain't no way we can get a bond today?
No, it's not my case. Judge Garcia has set you no bond, so you're not going to have a bond until you can see her and see more about the case. But right now, she's got no bond on you.
All right, thank you, sir.
Yes, sir. Have a good day.
Yes, sir, you too.
Thank you. We have Jesse Burnett next. How
you got my good? How you got my last name spelled?
Well, we've got it. The first appearance paperwork has Burnett.
Yes, sir.
Okay. So, Mr. Burnett, you're here because you're accused of a failure to appear. Judge Garcia has issued a no bond warrant for over in circuit court. So you're going to be held until you can get over there and try to get this case resolved. He's probably going to be on the next pretrial docket. Mr. McDaniel or ladies, down within the next pretrial docket, seeing felony court is
15th, I think.
Can't be. It's got to be one in July. No way they'd skip a whole month for pretrials.
Wait.
Felony. You don't have felony pretrials at all in July? I've never seen that before. So what I'm going to do is I'm going to ask Mr. McDaniel to notify your attorney in the case if you got to the point of getting one appointed. Who was that, Mr. McDaniel?
Owens.
So Mr. Owens will be notified by Mr. McDaniel that you're in jail with no bond, and Mr. Owens will come and see you at the jail. He'll tell you more about your court date. I'm being told there's not a felony pretrial docket for July, which is possible, but that's very, very rare. But your attorney will talk to you more detail about that. Any questions, Mr. Burnett?
When do you think he'll come to see me?
Mr. Owens is he's pretty, very, very efficient. What do you think, within a week or so, Mr. McDaniel?
He usually goes out there at least twice a month. So within 2 weeks, that was probably less than that though.
And Mr. Owens stays on top of his cases very well. So I would expect him to see you in the next 5 or 6 working days. Okay.
All right. Thank you.
Yes, sir. Have a good day. The next first appearance case we have is Sterling Crumpler. Mr. Crumpler, good morning. Mr. Crumpler, you were first appeared this weekend. Looks like you were set a bond in the new charge and a no bond in the VOP. Mr. Crumpler, let me deal with the VOP first. In the VOP case, what I do is, at the request of the circuit judge, we have an agreement where we put a 10-day hold on people. And what that does is that prevents you from sitting there for weeks and weeks with no affidavit being filed. So we're going to change that no bond to a 10-day no bond. So what that means is that I'm going to ask Mr. Mitchell to notify the probation office of your arrest. They may know about it already. They have 10 days to present Judge Garcia or myself with a VOP warrant, and we'll see if the judge that signs the warrant, if they sign a warrant, and the second thing we'll see is if they give you a bond on the warrant. So on the VOP case, you're going to be held for 10 days. That 10 days starts today because this is the first day they can be notified of your arrest. Mr. McDaniel, anything we can do on the misdemeanor he's already got a bond on?
No, Your Honor. He has a bond of 1,000. So if he posted.
So if you post the bond, you won't be released because of the VOP hold. Just be aware of that. But I'll see you in 10 days or possibly before then. Mr. Crumpler, any questions?
No, sir.
All right, sir. Have a good day.
Sir.
Casey, thank you. Casey Brannon. Ms. Brandon, good morning. Ms. Brandon, you're here for a hold out of Houston County, Alabama. I know that you've had a chance to speak to Mr. McDaniel about our Florida's waiver of extradition process. Ms. Brandon, do you have any questions about that process? I need you to answer out loud. Any questions?
No, sir.
Ms. Brandon, do you want to waive extradition and go to Alabama voluntarily and address these allegations against you, or do you want to contest extradition?
Let's just go on with it.
Okay, so the corporal.
Because either way, I keep getting locked up.
Go ahead, say that again, ma'am.
Either way, I keep getting locked up. I can't even get a chance, a chance at life, and I keep getting locked up for no reason.
Yeah, Ms. Brandon, I don't know the details of the charge in Alabama. They've just told us that they want you. Let's see if they got any details on the type of charge or anything. Corporal, I don't see anything. Sometimes we know the charge specifics and sometimes we don't. Corporal, actually, I do see something. What do we have here? They say no bond, and the allegation is, well, Mr. McDaniel.
Probably a violation of some kind of probation in Alabama, but I don't know that. She just got put on probation in Jackson County about 10 days ago. So
this says you failed to appear for arraignment on 6/18. Were you in our jail on 6/18?
No, Your Honor.
Okay. So that's what you're accused of, is missing an arraignment date. If you were in our jail, I was going to ask the jail to send some paperwork with you reflecting that. But if you weren't in our jail, then obviously I can't do that. So if you want to waive extradition and deal with this allegation in Alabama, you may get a bond when you get up there. You may not. I have no idea, but you don't have one at this time. So do you want to waive extradition and go deal with this? Is that what you want to do?
Yes, sir.
And Corporal has a form for you to sign, a waiver of extradition form. Mr. McDaniel, you satisfied she's doing this freely and voluntarily?
Yes, sir.
Thank you. Ms. Brandon, what'll happen next is if you're still here in 15 days, I'll see you because I try to keep a track of the cases and see what's going on. They have 30 days to pick you up, but frankly, Houston County is so close and they're so efficient. You're probably gonna be back in Houston County within 2 or 3 working days. But just to make sure it doesn't slip through the cracks, if you happen to still be here in 15 days, I'll see you. On the Houston County case, I don't think I've ever had that happen. They've always picked people up within a few days. And again, like I said, once you get up there, you'll find out if you got a bond or not. Any questions, ma'am?
No, sir.
Have a good day. Mr. McDaniel, we had a couple of possible bringbacks for possible pleas. I need to see Mr. Michael Barnes.
Yes, Your Honor.
Michael Barnes is next. Mr. Barnes, good morning. Mr. Barnes, at first, when I saw your name on the first appearance list, I thought you had posted bond and gotten the same charges again, but that's not what happened. Thankfully, you're just being brought back up to see if we can resolve the cases that I first appeared you on within the last week or so. I'm appointing the public defense officer to represent you for first appearance purposes. Please listen to Mr. McDaniel, your attorney, sir.
Your Honor, I spoke to Mr. Barnes in 25348 CT is going to enter a plea of no contest to the charges as listed. We understanding he'll be sentenced to 30 days in the county jail. He'll have 10 days jail credit. There'll be a fine of $1,078. He'll be adjudicated guilty, and this will resolve this case today.
How much credit did you say? 10 days credit. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Barnes, did you hear that agreement?
Yes, sir.
Mr. Barnes, any questions about that agreement?
No, sir.
And Mr. Barnes, is that the plea that you would like to enter to resolve these 2 cases?
Yes, sir.
Mr. Barnes, I will accept your plea of no contest in case 25-348 CT to the charges of no valid driver's license and driving under the influence. A judge who guilty of those offenses sentenced you to 30 days in jail in each case concurrently. That means it's one 30-day sentence. They're running at the same time. It's 2 sentences, but they're running at the same time. So in essence, it's 130 days. You have credit for 10 days on both sentences. That means you've got 20 days left at most. The reason I say at most is you may or may not get gain time under Florida law. That's between you and the jail. $1,078 court costs and fines are imposed in the DUI. That's set by state and county law. There are no court costs and fines, or I'm going to waive the court costs and fines in the other charge of no valid driver's license. Mr. Barnes, when you finish this case, you're through with this sentence. When you finish this sentence, you're through with the case. No probation to follow. Mr. Barnes, any questions?
No, sir.
All right, sir. I wish you the best. Sir, it will be a civil judgment if you don't get it worked off. You may or may not get it worked off, Mr. Barnes. So just for my benefit, when it's that kind of situation where it's almost impossible for them to work off that much with that short of jail sentence, they get a partial. Can they have a partial court cost and fines? In other words, like if they're on probation, we don't let them work off part of it. Normally it's all or nothing, but in jail, so if they work off 500 hours, that's $500 comes off their court costs and fines. Okay. And Mr. McDaniel, do I need to see Carmen Harrington?
Yes, Your Honor.
Carmen Harrington is next. Ms. Harrington, good morning. Ms. Harrington, you're here because you were first appeared, I believe, on Friday and set a bond. Ms. Harrington, the criminal history I was provided this morning was a Florida criminal history, and it showed nothing, but I show an Illinois address. So I contacted Sergeant Gross, and he said their criminal history shows no prior history anywhere. Is that correct, ma'am?
Yes, sir. I've never been in trouble with the law.
And Ms. Harrington, that offer that was made to you this morning was based upon that information. Ms. Harrington, you live in the state of Illinois, is that correct?
Yes, sir. I'm a senior at Illinois State University for geology. I graduated in a year.
Okay. Do you have any ties to Jackson County, or are you just passing through?
I was passing through. There was an injunction hearing for my son and I in Volusia County, and we were on our way back headed west on 10, going back towards Lafayette, where my mom is. And we were going to spend some time with my mom because my father's funeral is in July.
So Ms. Harrington, thank you for that additional information. So Mr. McDaniel, I think there was offer made. I'm going to appoint the public defender's officer to represent you, and we'll see what your position is. Mr. McDaniel.
Your Honor, I spoke to Ms. Harrington in case number 25351 CT. She's going to plead of no contest to the charge as listed. The understanding should be placed on probation for 11 months, 29 days, $1,078 in fines, 50 hours of community service work, a DUI school, substance counseling as directed by probation if needed. She may take that also to the DUI school. She has to be signed up for that DUI school in 60 days, minimum driver's license, suspension, adjudication of guilt.
Thank you. And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Harrington, did you hear that agreement, ma'am?
Yes, sir, I did.
Ms. Harrington, do you have any questions about that agreement?
No, sir, I do not.
And ma'am, is that the plea that you would like to enter to resolve this charge?
Yes, sir.
And I feel confident, knowing Mr. McDaniel as I do, that he's already explained to you written monthly reports that you don't have to come back here every month. You just got to report monthly by mail or email. Do you understand that?
Yes, sir, I do.
Ms. Harrington, I'm going to accept your plea of no contest then to the charge of driving under the influence. I'm going to adjudicate you guilty of that offense, which is required under Florida law. I'm going to sentence you to 11 months and 29 days probation. Ms. Harrington, you'll have the standard conditions of probation plus the following special conditions. You'll pay court costs and fines of $1,078, successfully complete substance abuse counseling. If you choose to do AA, we limit that at 12 classes. You've got to do 12 classes. If you're enrolled in the DUI school within 60 days, then the DUI school itself will count for your counseling. You won't do any separate counseling. 50 hours of public service work are required by state law. Successfully complete the DUI school. I do recommend the minimum driver's license suspension. And Ms. Harrington, that is, that's everything I had in this case. Mr. McDaniel, anything on behalf of Ms. Harrington?
No, Your Honor.
Mr. Mitchell, on behalf of the defense?
I guess, did you mention possible early termination?
I did not. Ms. Harrington, there's also the possibility of early terminating you in this supervision. The way that works is if you do half the probation, ma'am, and you have no violations, you get everything done, you very well may get off at 6 months and not have to do the full 1129.
Yes, sir.
Ms. Harrington, give me just a second here. Let me see the attorneys at sidebar, please. Okay, so Ms. Harrington, what we were talking about is based upon you have no prior history, ma'am, and the complaint, the information in the complaint, Mr. McDaniel's concern that I think is giving you a DUI based upon this complaint at your first court date. And I don't want you to enter a plea just because it's going to get you out of jail and get you back to the state of Illinois. So in reviewing the complaint, I think Mr. Mitchell is willing to concede or modify that plea agreement. So I want to ask Mr. McDaniel to put that on the record, make sure Mr. Mitchell is okay with that. And let's see if this is what you want to do instead of the original plea. And Mr. McDaniel, again, I still have no problem considering other release options, but that would mean you have to come back to court if we did something like that.
Thank you, Your Honor. So Ms. Harrington, the judge is based on the complaint and stuff, he is willing to give you some kind of option, but you would have to come back for a future court date from Illinois or wherever you're coming from. So you may want to just take this option here, but I'll let you have both options. It's some kind of additional release option. Another option is they've made an offer, the state has amended it to a reckless driving with alcohol. It will be the same conditions, except that you won't have adjudication it will be withheld. It'll be $1,078 in fines, 50 hours of community service. There'll be no driver's license suspension. There is the DUI class, which you still got to take. You're going to have to take it no matter what, probably to get your license reinstated. But you won't have the DUI. Is that something you're wanting to do, or do you want to try to get some other kind of release option?
The other release option sounds better because I graduated in a year, and if I don't have that on my record, that would be good. Will I still be out of release?
You have to come back for a future court date or
That's not a
multiple court
problem.
dates.
That's not a problem.
I have no problem offering you some type of conditional release or a normal standard conditional release. That will mean you would come back to court though in August in person.
Okay.
For an arraignment date. Now, the exception to that is if you hire an attorney, that attorney may appear for you. That's in any case. But otherwise, you would have to be here personally in August. So you would rather do, it sounds like you would rather do that than resolve the case and have this on your record. Is that correct?
Yes, sir. Absolutely, sir.
And even knowing that the state's willing to reduce it to reckless driving, you still would rather come back to court and try to deal with it, correct?
Yes, sir. Absolutely, sir.
Ms. Harrington, I want to explain to you the conditional release then and make sure that's what you want to do. A conditional release means that you're under court supervision while the case is pending. You have to call in once a week. You don't appear in person. You appear by phone once a week. You can't be charged with any crimes while the case is pending. You've got to pay a cost of supervision of $30 a month. And those are the primary conditions of conditional release. You cannot possess or consume any substance any controlled substance unless you have a valid prescription for it. So if you have a valid prescription, you can possess it in compliance with the law, but you can't have anything you don't have a valid prescription for. This is not an alcohol-related DUI, but even though it's not an alcohol-related DUI, every conditional release has a condition not to possess or consume alcohol. So you can't possess or consume. Is that right? Or I'm just about probation. Yeah. So every conditional release has a condition not to possess or consume alcohol because that's a huge percentage of our cases involve the use of alcohol. So knowing that you're going to be reporting, you would not have to post a bond, but you would have those rules to follow. Do you want to accept that conditional release, Ms. Harrington?
Yes, sir. I do want to accept the conditional release.
I'm going to grant you the conditional release in lieu of the bond that was set this weekend, Ms. Harrington. What I'm going to do is I'm going to ask the probation office to give you a notice to be in court. What date, ladies? July the 28th. I said you would have to come back in August, but actually the August date falls at the end of July. Your court date will be July the 28th at 9 a.m., ma'am, and you have to be here in person unless you've hired an attorney and that attorney appears for you. So you'll get that notice when you get to the conditional release office in a little while. What's going to happen next is this. You'll get to use the phone before you leave the jail. The reason for using the phone is in case you need to contact friends or family for transportation purposes.
Yes,
After you use the phone, you will then be brought to the Jackson County Courthouse because that's where the conditional release office is at. They will meet with you here at the conditional release office. They'll explain the conditional release to you. They'll give you a copy of all the rules in writing. They will give you a notice for your next court date. That will be the only notice you get. You won't get mailed anything, just the one they put in your hand. And once they do all of that, they'll give you a chance to ask questions, and then you'll be free to leave. So if you do contact friends or family, you can tell them you can be picked up at the Jackson County Courthouse in roughly 45 minutes from now. Ms. Harrington,
Jackson County, what? Jackson County Courthouse?
Here in Mariana is probably 3 or 4 miles from the jail, maybe, I'm guessing here. Ms. Harrington, do you have friends or family local?
Yes, sir. I have one friend from Louisiana. She stayed here since Friday. She's been here since Friday trying to help me. She's around here to be able to pick me up.
She's not in the courtroom, is she? I'm gonna make sure she's not in the courtroom. She's not.
Her name's
Okay,
Chris. Okay.
She has your son now, correct?
No, sir. My son's with my mom.
I don't have one.
Where's that at? Because your son was with you when you got arrested, right?
No, sir, he was not. My son was with my friend in Louisiana. My mom would go pick him up from my friend's house in Louisiana.
So you can contact whoever you wish, the friend or whoever, but you'll be free to leave the courthouse in roughly 45 minutes, okay?
Yes, sir.
Have a good day.
Thank you.
That court date is July 28th at 9 o'clock, ma'am.
July 28th, yes, sir.
Let's finish the day off right. Da 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 da. Dungeon court.
And are you calling E. King?
Yes, sir.
Fails bringing you a copy of the charge. The state's alleged that at Fayette Township on June 29th, you knowingly caused or tried to cause physical harm to Alexandra King, who's either a member of your household or a member of your family. So the charge is domestic violence. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
No.
You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, have one appointed, make the state prove the charges beyond a reasonable doubt. Those are your rights. Do you understand those?
Yes, sir.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed?
Can I get my own?
Yeah. How much time do you need to get your own lawyer?
I don't know. I mean,
Well, let me give you some time frame and see if you think you can do it within that time. So, how about the 25th of July? That's almost a month.
okay.
Think you can do it by then?
Yes, sir.
Okay, July 25th will be your next hearing. And it will be a pretrial at 10 o'clock. You're going to put down that you will hire lawyers. I'm going to continue your bond. You posted a bond, so that's continued. And then the question to the prosecutor is, is there a protection order requested? Is the,
Yes. With order of marriage.
is it a problem for you to stay away from Alexandra?
No, sir.
Okay, you don't live together.
No, sir.
Okay, so while this is pending, you're not to go around her or contact her or post things about her. You know,
Okay.
because I want things to die down.
Yes, sir.
I don't want there to be another incident alleged to have happened. So just stay away, let things die down, come back to court July 25th, unless your lawyer says they made arrangements for a different date, then you come back the date they tell you.
Okay.
You have any questions?
No, sir.
Not guilty, please enter for you.
Thank you.
You're welcome.
Sorry.
We're ready for pre-trial.
Okay, we're starting pre-trials.
State of Ohio versus Aaron P. Brown, case number TRC 25502 A and B.
Mr. Dwyer's case.
May I approach, Your Honor?
Yes, set for pre-trial.
Your Honor, this is a case we resolved back on April 7th, it looks like. The state was agreeable to amend the charge to reckless driving, but they wanted Mr. Brown first to complete the 72-hour driver intervention program. It's my understanding that he's done so.
Okay, and I do have a copy of the completion certificate in the file. Anything you wish to say, Mr. Brown?
No, Your Honor.
Okay, it'll be amended to 451120.
Yes, Your Honor, that was the discussion I had with Mr. Hill.
I'll pay the $150 fine. Court costs. Can you pay that today?
He's going to pay that before he leaves, Judge.
All right. See the clerk pay it, there'll be no probation as long as he pays today. Okay, there was a fee, Laughter Center, $10 fine.
Thank you, Your Honor.
See the clerk.
See the clerk before we leave to pay your fine.
State of Ohio versus Brandon P. Haight, case number TRC 25998 A and B.
May I approach, Mr. Judge?
Yes. that for pretrial?
Your Honor, I discussed this with Mr. Shield at the court's request from the last pretrial. I don't know if you recall this specific case or not, but we had the trooper here today to talk to him about some issues involved in the case. So since the last pretrial, we've been able to identify 2 people who may be witnesses. I haven't had an opportunity to speak to them yet. We've also obtained today the 911 calls related to this incident, so discovery is ongoing. I think the police officer today did shed some light on his observations and his opinion. So if we can have one more pretrial proposed in that entry, I'm going to meet with Mr. Haight. We're going to go over all the discovery and see if a trial is going to be necessary or not.
All right, so the pretrial is July 28th.
Okay.
July 28th will be the pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus KCR Hudson, case number TRC 25-1010, A and B.
The largest case at the pretrial.
Your Honor, this is the case Mr. Hill and I discussed prior to court convening. It's my understanding we've got a resolution in this case. However, it would require Mr. Hudson to complete a 72-hour driver intervention program. We've talked to Mr. Lutz this morning. He says he has availability on here for the local program on July 31st. I've talked to Casey about the opportunity to do it. He could do it anywhere in Ohio, but I think he plans on doing it here locally. So,
Come back after that's completed.
yes, if we can.
You have dates in August that are good for you?
Yes, could we do it on the 18th?
Yes. August the 18th will be the next hearing for pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jeffrey J. Arnold, case number CRA 24-1021. Jeffrey Arnold.
Mr. Morford has the code, and Mr. Murphy is on the docket.
All right.
Or the cross-filing, it's a cross-filing judge, and I don't know where my client is.
What's the, Mr. Morpheus?
Judge.
Oh, Murphy, Michael Murphy, judge. Excuse me, yes, Michael Murphy, Mr. Morpheus.
State of Ohio versus Michael Murphy, case number CRB 25-151, CRB 24-823.
Mr. Murphy's in residential treatment and see him on the docket. But he's doing well. He's a house leader and doing everything he needs to do.
The only thing I know, Judge, on my case, it was a cross-filing to be dismissed upon, I guess one of the gentlemen had to pay the cost. I don't know which one was assigned cost, but it's been a while since I've had contact from my client.
Well, the costs haven't been paid on either case.
That's what I was afraid of.
He isn't able to work yet. He will be able to work at 126. He's close, but not there just yet.
They have 7 days, Judge, and I'll see if I can find him. Because I'm shocked he's not here, considering it's supposed to be dismissed, but
Okay.
I'll reach out.
Mr. Arnold has 7 days to appear for one issue. Since Mr. Murphy is in treatment, I'd rather just continue his. And he's gotten a good report. And he has another case that's unrelated to this one too.
I think it's a domestic.
It is.
He's just started or how?
He's been there for about he's going on his 3rd month, so they can't work until day 126. So we'll help him find employment once he's eligible to do that. But he's doing really, really, really well in the program.
Okay. Well, let's look at mid-August then, for a day. What's your availability, Mr. Moore?
I think I'm pretty good in August, Your Honor.
Okay. How about the 11th, August the 11th?
I have that's the one day I do have a trial, Judge.
15th?
I'm clear there.
Okay. Michael Murphy, at his request, is continued to August 15th.
Thank you, Your Honor.
We'd wait
We
time
got
to
two
you
different,
guys.
I think, two different cases involved.
We did. 25-151 and 24-823. So he's inpatient treatment and doing well, so I was just going to continue.
So the one that's 151,
Is the one with the code attendant.
Terry Krantz is one.
I have that. I'll take it, Your Honor.
Jeffrey Arnold's my cross-file.
That's his mother, Terry is, I believe.
Yeah, I have that case that's also set for today. This crossfire.
Is she here?
Yeah, she's right here.
Okay, you can come up. Okay, I was thinking it was the other case that was the code attendant cross-bond. So
I think they might both be. But different individuals, I'm not certain of that.
State of Ohio versus Terry Krantz, case number CRB 25-150.
So this was a 90-day continuance as well. We had discussed, since we were here last, Ms. Krantz has actually sought and attained a civil protection order regarding the co-defendant. He still has belongings at her home. She has them packed up in a single room and ready to be picked up, but she would rather he send a third party to pick them up rather than come himself because of the protective order. I told her I was going to tell Mr. Morford about that, and so I'm putting that onto the record at this point. I don't think there's no indication she needed to pay court costs, and there hasn't been any further problems. I believe the state's intent at this point would be to dismiss Ms. Krantz's case. Now, I don't know whether Mr. Murphy was supposed to pay court costs or not. I'm not certain of that.
My notes were it's going to be dismissed with payment of costs, but
That's my notes too, Your Honor.
does the state want to dismiss her case though, without payment of costs?
We're not opposed to doing that.
Okay, so Terry Krantz, 25-150 will be acknowledged without cost. Oh, okay. She does have the assigned counsel.
Okay, so you want $25 to the court. Can you do that? She can do that today.
All right, see the clerk on that. That's her only cost. On Michael Murphy, since he's in treatment and doing well, I'm going to continue, we'll keep it continued to August 15th.
Sadly, friends, we've reached about that time where I should move on to other things, and you all probably have things you should do as well. But I am happy that we finished on Dungeon Court and we were able to laugh at some things. And if you're a new channel member lurking out there, we did a whole brochure on Dungeon Court because we felt here at the bunker it was worth it. And it's available to channel members. You need to reach out to me via the members-only email, and I will send you a copy of it. If you don't know what the members' email is, go to any pre-show, and it'll be on your screen. So just pull that up, and you'll be able to see it and get yourself a copy of the brochure. It was funny. You'll enjoy it. Speaking of enjoyment, I hope you all did enjoy today. I know I did. And I look forward to seeing you all tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members as always. If you haven't already, do me a favor, hit the like button on the way out. If you're lurking out there and haven't subscribed, please do so. If you're not a channel member and want to be one, there's a link in the pinned chat. Lindsay said it started off dark, but all in all, a good day. I would tend to agree with you, Lindsay. It was definitely dark. But that's part of what we do here. We just pull things up and we see how it goes, and we move from court to court, and we got something different every day. I think that's part of the charm of it. I did see you sent me the email too, Lindsay. Thank you. Don't make me write my paper. Ashley, I won't make you do anything, but you know what you should probably do. All right. We'll leave it there. I'll see you all tomorrow, friends. Thanks so much. Take care. God bless.